ABLPL number 6352 by 17 my lord. May I pray for first or second my lord?
The impugn is the order at page what?
Absconding charge sheet and thereafter NPW
Annex
issued.
2.
Annex 2 is the impugned order my lord. NPW issued.
You are Mr.
Panchanan Panigrahi my lord.
Panchanan Panigrahi. No, I'm not talking.
Kamini Malik not named in the FIR my lord, but omnibus allegation against 30 to 40.
I am not on the allegation. I just default. Accused number?
As per FIR 19. Accusation serial number 19. FIR accused.
No. You just see Annex 2. Where is your name?
16 my lord. Serial number 16.
Achha, ठीक है. What was it?
My lord, in fact, my lord, her name is found placed in the FIR, my lord, but earlier occasion,
She was granted bail.
Granted bail, my lord, he has not granted bail, my lord. Highly anticipated bail. Direction given by the Honorable Court. If there is the petitioner will appear before the court and release court bill or release on bail. If charge sheet has not been filed, my lord.
Charge sheet is now filed.
Yes, my lord.
By the time charge sheet was filed, my lord.
So, anyway, he has to seek bail now. Surrender and take bail.
My lord, that is order that, my lord.
The petitioner is assailing the order dated 30th 7 2018. 2018 order now you are coming.
My lord said for that. Thereafter file anticipated bail application 2023.
2018, whereby the learned JMFC Bhuvan in court of learned JMC Bhuvan issued NBW against her for default in appearance. The learned counsel for the state oppose the prayer made by the petitioner and submits that meanwhile his anticipatory bail application before has been disposed of by the coordinate bench, directing her, she is lady na?
Madam.
Directing her to appear before the trial court and seek regular bail. Next paragraph. Having heard the parties, I am of the opinion that the impugn order dated 30/7/2018 is to be need to be quashed, and the accused of the petitioner is directed to appear before the trial court and seek appropriate remedy under law to for enlargement for remedy on law for grant of bail. This poster.
If that order will quash, my lord, there are two accused persons. In respect to two accused persons, that order was, my lord. In respect of the petitioner.
The order dated 30/7/2018 qua the petitioner. Qua the petitioner. Next. Yes. Please go there.
Item 2. May please, my lord. Here the petitioner challenging the order of cognizance, my lord. My lord, kindly peruse page 11, Annex 2. The police after investigation submitted final report, my lord, stating false FIR, my lord.
Where is that? Where does it say false FIR?
Page 11 is the final report, my lord.
This is the final report.
Yes, my lord. Page 14, the gist of FIR, my lord. The complainant, my lord, middle of the gist, my lord, the complainant fell in one-sided love with the alleged accused prior to few months of the alleged occurrence when the parents of the alleged...
Where are you reading?
My lord, page 14, my lord.
Yes, I am on 14 only.
Yes, gist of the affair, last para, my lord.
Yes, para 16, during the course of investigation, read there. During the course of investigation.
Yes, my lord, yes, my lord.
Ah.
During course of investigation, the then SI BK Mishra examined the complainant and witnesses, and other witnesses had recorded their statement under section 161 CRPC, visited the spot in presence of presence in
And other
presence of
witnesses,
complainant and prayer.
see
Other
the
witness.
command certificate and so on.
Yes, my lord, yes, my lord.
And
He was on duty at Sambalpur bond, my lord.
You read it first, let us understand.
Yes, my lord. Seized command certificate by CC number 0078978 issued on 25/8/16 left in the Zima of command certificate. So to from Sarat Jani, Assistant Commandant, 1st Battalion Dekanal, and also seized one Micromax mobile having 2 SIMs, black model, having so and so from the possession of Kunal Naike, 462 1st Battalion Dhenkanal, and left the Zimma during investigation. It is well proved that the victim Subhadra Naike, aged about 16 years, is the only daughter of the Ganeshwara Naike. She is now prosecuting her study in class X in Bodaswal High School. Her father is a daily laborer. On the other hand, Kunal Naik, aged about 24 years, is the eldest issue among the other issue. Kalash Naike, both the complainant and alleged accused hail from same village Tulasipasi under Kamakhanagar PS in the district of Dhenkanal. Alleged accused Kunal Naik is working as a Sipai in 1st Battalion OSF Dhenkanal. The complainant fell in one-sided love with the alleged accused prior to few months of the alleged occurrence. When the parents of the alleged accused searched for a bride for the marriage of their alleged accused son, parents of a victim gave a proposal for the marriage of a complainant with the alleged accused, to which the parents of the latter proposal for marriage complainant of the alleged accused, to which the parents of the latter did not agree to the proposal. Being aggrieved, complainant reported a false case of molesting against the parents of alleged accused on the behest of her parents in order to pressure on the alleged accused and his parents to agree for the marriage with the complainant. The allegation of a complainant could not be proved by any one of the witnesses. Moreover, the presence of alleged accused during the corresponding time alleged occurrence at Borogad, not at the alleged spot, was well proved. Considering the command certificate issued to him for law and order duty and the CDRS of his mobile phone, the case was supervised by Sri P.K. Tripathi, IIC Kamakhanagar PS, and he opined that it is a false case under section 341, 294, 223, 354B, 506 of IPC 12 of POCSO Act. And further in the S note, the SO imported some instruction and a SI BK Mishra carried out all the instruction imparted in the S note and submitted a compliance report to the SP Dhenkanal with a prayer for orders to return the case as
the IO. See, in this case, the IO is changed and the new IO files the charge sheet. The earlier IO says that there is no case made out.
My lord.
How cognizance could be taken?
My lord, while the learned magistrate, my lord, perusing the record, found that the FIR and also the 161 statement victim found that there is a prime facie case made out against the accused, my lord. For that reason, the learned court will have taken cognizance.
These are routine cognizance orders.
My lord.
See, just see,
my lord.
There is nothing is made out against them.
In fact, my lord, the court can take cognizance, my lord, if satisfied on the police report, my lord.
What satisfied if the police says that the earlier IO was there is no witness, there is no evidence, nothing, and it was proposed to final report.
That is true, my lord.
IO changed, the other IO comes and writes that and files it.
But in fact, my lord, bare reading of the FIR and 161 statement the victim, my lord, case is made out, my lord. My humble submission, the master right will take cognizance. Even if police submitted
they read 161 there. Where from you got that 161?
Well, first read out the FIR, my lord. Then I'll go to the
FIR investigated. We have read the charge.
More nama Sudra Naik.
What are you reading?
161 statement of the complaint.
Yes.
More nama Subhadra Naik, Pita Ganeshwar Naik, Tulasipasi.
Which page?
Page 23, my lord.
Upasthai.
That was converted to FIR.
No, my lord. After FIR, this statement was recorded by the same police, my lord, who was found on, my lord. For that reason, my lord, honorable court will right will taken cognizance, my lord. My lord, I will read out. Fourth, ମୁଁ ବଡ଼ସୁଆ ସ୍କୁଲରୁ ଫେରୁଥିବା ସମୟରେ ଆମ ଗ୍ରାମର କୁଳାନିଧି ପିଟିସନର ନାୟକ ମୋର ସାଇକେଲ ଅଟକାଇ ମୋର ସାର୍ଟକୁ ଟଣାଟରା କରି ମୋତେ କୁଣ୍ଡେଇ ଧରି ଧମକ ଦେଇ କହିଲା ଫିଲ୍ ଦି ଲାଙ୍ଗୁଏଜ। ମୁଁ ତାପରେ କୌଶଳ କ୍ରମେ ଖସି ପଳେଇ ଆସିଲି। ଫିଲ୍ ଦି ଲାଙ୍ଗୁଏଜ 294 there my 350 roll made out, my lord. But even if, my lord, the 161 statement taken into consideration, my lord, the case prime has 354A and also 294 is clear made out, my lord. And
Then anyway, we have to hear the informant.
my lord,
Before
informant,
watching,
my
we
lord,
have to
I will
hear.
also obtain the case diary, my lord.
Right.
My lord.
Write down.
Notice may be issued to the
Simple, I will issue notice.
my lord.
Notice to the complainant. Huh?
My lord, friend will
Police
file the
part number
requisite, my
2.
lord.
Copies.
Yes,
And also he will file the requisite.
Requisites, my lord. Opposite one, 2 is
For
the
notice of opposite
private
two.
party, my lord.
Filing requisite. Okay. Date. Let us hear on 29th.
No coercive action, my lord.
What no course action? This is not a court for anticipatory bail in disguise.
My lord, Sakhi start.
First thing is you have other remedies.
Yes, my lord.
Don't convert 482 court to a 438 court.
Must stay
Because
the
some other court is not granting
the
you,
further-
so you filed.
stay the further proceeding, my lord. Not like Sakhi ହେଇଗଲେ ପୁଣି କିଛି ଲାଭ ହବନି, my lord.
29th ରେ କଣ ହେଇଯିବ? 29th ରେ କିଛି ହବନି। Quash କରିଦବା। We are not
Yes,
so
yes,
powerless. We can
ସେ
quash
ଜାଗା
it.
पर ନଥିଲା ତ, my lord. It is clearly proved, my lord.
That's right, but
Yes, ma'am.
161 statement
ଅଛି।
he has read out.
Seat ଆସିଲେ ଜଣା ପଡ଼ିବ।
Yes.
29th.
29th.
Item 3. Petitioner challenge the impugned order. Rejection of the.
Item 3, my lord. Vigilance council is another case, my lord.
Okay,
Pass over.
pass over.
Pass over. One pass over.
Item 4.
May I please, your lordship?
Yes.
Lord, earlier, my lord, this is a case under section 498 read with other charges. Now, my lord, the informant has made a compromise which has been accepted by this court, and
Have they agreed to?
already FIR has been quashed against mother-in-law, father-in-law, and the husband.
He was there.
Now, the petitioner is the brother-in-law. He has also accepted the permanent alimony. Yes.
Where is the? You are appearing for the informant? Huh? With us. Your brother-in-law.
Brother-in-law, none of the.
Oh, this is the Sumitra is the mother-in-law. Tarakanto is the.
Against the petitioner, my lord, 376 by 511.
No, self allegation against father-in-law and
So far, for that
brother-in-law.
compromise between the husband and the family-in-law.
Lordship will
My lord,
not
he is the
give
brother-in-law.
161 statement.
376 by 5 million there. For that, I want,
Yes.
my lord, the seal file the affidavit, my lord.
Yeah.
The
No, in this order also the complainant, the girl was.
in respect of the mother-in-law,
in
husband, others,
court.
my lord.
Others.
She appeared in the court.
My lord. So far, the
Bring her tomorrow.
my lord,
If you have settled,
my lord,
Oblate.
we'll settle. We'll
Mal.
bring her tomorrow.
Oblate.
Tomorrow.
Oblate.
Take it on record and bring her.
Oblate.
Tomorrow, first item,
Sure.
because he will come and don't detain her. First item, tomorrow.
Oblate.
I'm sorry, my lord, item 3.
Passed over. 6 now.
Item 3, madam.
Oh, after pass over.
Yes, thank you, lordship. The petitioner challenge the impugned.
This
order
is
from
item
the-
5.
Item 5. Item 5. Read a pass over.
3. Pass over ହେଲା ପରେ pass over time ରେ ରଖିଆ ହବ।
Item 5.
Yes, 5.
Application for passing of proceeding on the ground. In the meantime, the petitioner has returned back the amount. Lordship is the page 13. Turning to 13.
13, huh?
Yes, ma'am. Middle paragraph.
Yes.
The informant who is present in the court submitted the dispute between her with the accused. They already
1 minute,
settled.
1 minute. Where are you reading? 13.
13, middle paragraph.
Para 3 you read. It is submitted by the land council.
Yes, yes. The informant who is present in the court submitted that dispute between her with the accused has already been settled and she has received demand draft for rupees 3
Where
lakhs.
where are you reading?
Page 13 million. Annexed to page 13 million.
13, the top,
No, middle bar one.
the informant who is
Yes.
present.
The informant who is present in the court submitted the dispute between her with the accused has already been settled. She has received demand draft of rupees 3 lakh from the daughter of the accused towards full and final payment of money received by the accused earlier from her to sell the land.
There is the record, the investigation of the case will progress substantially. The accused person is in custody since in the meantime. She must have felt the rigors of law. The accused person is residing. This is a bail order.
Yes, madam. Bail, my lord, they already paid the amount, my lord. And also file affidavit, my lord, before the bail court, my lord. They already received 3 lakhs
But,
for full final.
She has to file affidavit before here, my lord.
The affidavit has to be filed here, joint affidavit.
Please notice, my lord.
Kali attack, no? Sir, joint affidavit file there.
Notice to opposite party number. Very opposite party number 2. Sarojini, na? Sarojini Rao. Then you come next week.
What we will pay time.
She is there in what is that?
Bandari.
Banki, nearby. Next week, then put it on 16th, 1/6. Notice to opposite party number 2.
I have further, pay up further.
No further. Settlement, once you settle, what is the question of further?
16, my lord.
16.
Item 6. Item 6.
Not traced. Dismiss as withdrawn, being not traced.
Item 7.
Pass over 7.
Item 8.
May I please? May I
Yes.
please, Your Lord? The officer in this case, the petitioner is challenging the learned trial court has been rejected under section 311 petition, Your Lordship. On the ground that, Your Lordship, the 311 petition has been filed after the 1 year and 9 months. So, Your Lordship, the petitioner filed a 311 petition as because, Your Lordship, the recall of the witnesses.
Which witness?
PW3. That is, Your Lordship, namely Sweta Padma Naik.
What is the offense, by the way?
Offense, Your Lordship, under section that is, Your Lordship, 452 and 307 and Your Lordship 379.
What these witnesses have said?
Your Lordship, the
Sweta
witness-
Padma Naik.
Sweta Padma Naik is Your Lordship, the victim. Your Lordship, he is the material witnesses, Your Lordship. And may I permit to read, Your Lordship,
Yes, read.
what she stated, Your Lordship. In PW3, Your Lordship, the informant.
Page.
No, sir.
Not given,
That
my
I
lord.
have not annexed.
That
How
are not,
will I read?
and also petition has not been supplied. Petition will say, my lord.
You want recall of one witness.
Yes.
Let us understand what she has said.
Hooray.
That is the vital document in 311.
Yes, Your
You
Lordship.
don't file, then how?
I'll file to the next yes.
I will file that.
You file it. That's very necessary.
Mm.
Very necessary.
May-
But do you have any problem? It is
No.
307 only. Do you have any problem?
I don't.
We'll give one opportunity.
My lord.
Yes,
Only one opportunity. Because 1 year of
My lord.
yes.
why to prolong unnecessary?
My lord, pass, my lord.
Only one
My lord,
opportunity.
only-
You fix the date.
Yes.
No further opportunity.
My lord, he has to file the questionnaire, my lord. In what question he wants to put, my lord. That is it.
Yes, sir.
Otherwise, my lord, the case will be lingering.
I know
Your
you.
Lordship, I undertook to that, Your Lordship, on that
Specific
effect, I
question,
will
ma'am.
not take any.
One, you tell the date. When are you going? When are you going to
Because of
bring?
Your Lordship, in trial court, today's date is fixed, Your Lordship.
The trial court will fix one date
Yes,
and you will supply the questionnaires.
yes.
And on that day, this witnesses will be examined and
Yes,
finished.
If the trial court found that the question is relevant for the purpose of
No, 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 সেটা তো
her
obviously-
examination.
Yes, obviously, trial court is.
Otherwise, my lord, they can.
So, এটা করে দেবো। The petitioner is
Data
has moved
subject-
this application challenging the order dated 25/7/2023, 2023, whereby the application moved by the accused under section 311 to recall PW3 Shweta Padma Naik has been rejected. Then, counsel for the state submits that the application for recall of the witness was moved belatedly. Therefore, the said application was rejected with the trial court. Rejected by the trial court. Be that as it may, the counsel for the accused submits that he needs one opportunity to re-examine PW3. Next program. The trial court, let the trial court re-examine, give one opportunity to the accused petitioner to re-examine PW3 on the before the date is fixed for the re-examination. The accused persons are directed to supply the questionnaires, proposed questionnaires to be put to the witness. The trial court would examine the relevancy of those questions and allow a singular opportunity for the purpose of the examination of PW3.
I know that.
Singular opportunity. One.
Well, yes, all right.
If this questionnaire, the relevancy, the trial court will see. Next.
Your lordship, may format your lordship or then certified copy, because today is the fixed trial court.
You inform.
Yes,
This is the order passed.
yes, I know that.
Next.
Item 9,
Kindly pass over.
9 passed.
then
Here, my lord, in this case, the petitioner has challenged order in taking cognizance as well as issuance of process in the case. Your lordship may see page 48, the order of in taking cognizance.
Yes.
Here, my lord, it is an unfortunate implication and cognizance has been taken illegally, my lord. Under
Bhagirathi
section
Maji.
302 by 201 by 34 of IPC. My lord, your lordship may kindly see the charge sheet as well as most relevant 161 statements I have filed. And your lordship will find that absolutely there is no material that in furtherance of common intention I have committed in murder. My lord, I may be permitted to read the statement of the co-accused who is involved in the case at page 33.
OAQ statement is not relevant.
My lord, the statement of the
Come to the charge sheet.
my lord, charge sheet, your lordship.
Charge sheet at page 29.
Page 29, my lord.
Just
Page
read it.
in page 31, your lordship, police has answered after conducting investigation is like this. Your lordship, relevant para, page 31 in the middle, my lord. May I, if your lordship will.
31, page 31.
Page
Yes.
31.
In the meantime.
In the meantime, my lord, police has answered this after investigation. In the meantime, at around 4:30 AM in the early morning hours, Chumki Maji, hard crime. Chumki Maji, my lord, he happens to be the daughter-in-law Bahu of this petition. Coming from the place where the deceased was staying. To verify the same, she went there and found the dead body of the deceased was hanging.
Hanging.
Immediately, she returned back, intimated the matter with his father-in-law. My lord, I am the father-in-law and mother-in-law, my wife. And sister-in-law, another Jaya, my lord.
Yeah.
Later, the house owner himself and his wife. Now, house owner, my lord, I am the house owner.
No,
letter,
you are the father-in-law.
I am the father-in-law as well as the house owner.
House
My
owner.
lord, in my house, this
Hmm.
unfortunate incident had taken place, the deceased has died.
Right.
Yeah,
Who's to open the
finding her,
unbolted door?
sir, my lord, his wife, who, my lord, this is letter, the house owner himself, and means to myself and his wife, my wife, pushed open the unbolted door and went inside the house of the deceased. Finding her child was crying, the wife of the house owners specified, what is the meaning of specified? I don't understand. Specified the child, whereas the house owner caught the ligature by using wooden paniki, thinking that the victim might be alive. My lord, it myself. Later, as the body fell down on the ground, he notices that the victim was dead. Hence, feeling
Fearing.
fearing reprise that they will be held responsible for this. The house owner untied the ligature and burnt the ligature near the bank of the pond, which is present just back of the house. Investigation of the case is completed. All the instructions.
Then you have some role to play.
My lord, your lordship, this is my lord had two babies. One of the baby cried in the early morning. Thereafter, my daughter-in-law went there, hearing the cries of the baby. I went there with my wife as well as my two daughter-in-law. I found that the body is hanging. So I caught the ligature back and it fell down. And with this regard, my lord, what is the background of the case is that.
And thereafter, what you did?
My lord, thereafter the ligature material, the study or what is that? That police says that was burned.
So destruction of evidence.
My lord, this is the allegation, and police has written here also.
No, that is the part of the investigation.
My lord, can it be with due respect, my lord? Can it be 302 201 by 34? Did I share any?
Or it's the cognizant stage. You can argue on charge. All these points, I'll keep it open. Argue on charge.
My lord, now my lord, NOW has been already been issued.
If you don't appear, NOW will be issued.
And in the meantime, so much of cognizance has been taken.
What I can observe is all these points. I'll keep it open to argue at the stage of charge.
My lord, may I pray one thing that under section 302, at least your lordship.
No, in the 482, I can't start framing charges.
My lord, for
There is no material. Then the entire charge sheet has to be read, and then I will be a court for framing charges.
My lord,
and if 302 is not made out,
against me, my lord, I don't
it's
say
all
that
right.
against co-accused it is not made.
May not be. You may be correct. I'm not saying that you are not correct.
Yes,
But the court of first instance has to see whether any charge is made out against you or not.
My lord, here police has written what I beg to submit your lordship. That for 302 Satyajit Maji, who was in love with that deceased, he is
You are absolutely correct. But at this stage, 482, you just imagine.
My lord,
I will be assuming the power of the trial court at this stage and start framing up charge.
my lord, with all respect, my lord, what I beg to submit the learned court below, while taking cognizance, should have taken cognizance exclusively to under section 302 and the active.
No, that is charge stage, it will be argued. Cognizance stage, see, cognizance is a very preliminary stage.
My lord,
He has taken cognizance, you argue on charge. All these points, I'll keep it open so that you may be discharged also, insofar as 302 is concerned.
but my lord, at the present, my lord, I will into trouble because 302 by 34 is there. Because I have not committed anything. Your lordship, there are enough materials to show.
See, if you show all these things, you get bail also.
My lord, your lordship may kindly pass a resign order so that, or direct me to surrender in the court below and pass a resign order so that this old man will not be harassed anymore.
Okay, I'll pass. I'll dispose it. And I'll keep everything open to argue at the stage of charge.
Yes, your lordship. But for the present, my lord, I may be permitted to surrender and I move my bail so that.
For surrendering, no permission is required. You can go and surrender.
On this same day, I can.
Do you need a court's permission to surrender?
My lord, in the court below, I can surrender. My lord, it may be, a direction may be given that so that I can move in the second hour in the court or in the.
No, that is the bail, that bail court can do it, not 482 court. My jurisdiction is limited.
Your lordship may kindly observe what For 302, my lord.
That is again, then this 482 petition is bail petition in disguise then. Then you try this and the bail says, I'll just adjourn it. Thereafter we will examine it. You get it bail, then we will examine it. That is the option.
Already filed anticipatory bail application for us.
In anticipatory bail, my lord, what is I was given.
You might not have got relief there, so you are trying here.
Charge sheet has been submitted. And during interim protection, my lord, charge sheet was
I'll
submitted.
then what I'll do is I'll simply adjourn it. You try a bail. Thereafter you argue it.
Let it be.
That's better idea.
Yes.
Simply adjourn.
Yes, sir.
If you try the bail, if you succeed there, you can very well
Yes.
try your luck here. But don't try your luck in this proceeding for bail.
Yes.
I'll simply adjourn it.
Next week, right?
2 weeks there.
Item 11.
Please, your lordship. Lord, the two petitioners before your lordship, they are in custody in connection with an FIR and section 21C and 29 of the NDPS Act.
Yes.
Lords, a charge sheet has been submitted against them, which I have annexed as Annexure 2, which is said to be a preliminary charge sheet, my lords, keeping investigation open. If your lordship will look at page 33 of the brief.
33.
Yes. The last paragraph of the charge sheet.
Yes.
Investigation of this case is not completed within 180 days. Stipulated period will be completed on 8 Act days. Case is pending further investigation. Hence,
133.8 is kept open. Yes.
my submission, my lord, says this. Under the NDPS Act, 36A provides, it gives the investigating authority the power to approach the court for extension of the period for submitting charge sheet. But nevertheless, they submitted a charge sheet under styled as a preliminary charge sheet, something which is foreign to law, my lords. And as a result, my lords, my 167(2) application could not be moved. The other difficulty is the cognizance has been taken by Annexure 3, my lords, without a chemical analysis report on record. A chemical analyst's report, my
This is
lords,
not a complete charge sheet. That's what the
Yes.
Supreme Court
not a
says.
complete charge sheet.
Unless in NDPS case, if you have filed chemical analysis, report,
Right.
that's not a complete charge sheet. So for that, you are entitled for bail.
If your lordship will give that observation and dispose of it, I'll move there under 167.
See, this is the Supreme Court says that without chemical analysis report, you can't throw papers on the court saying that take cognizance. It is not a complete charge sheet. So if
For
there is
that
no
reason,
complete charge
they
sheet,
have stated-
167(2) entitlement is there.
For that reason,
So
stated that
482, I can't do that, but he can very well go and do it.
even if there is there are my lord decisions, my lord, if the preliminary charge sheet submitted, my lord, the default bail could not be.
No, you simply say whether it is a charge sheet in the eyes of law insofar as one NDPS.
For that reason, my lord, I will return that
Because
preliminary
that
charge
matter
sheet.
is now already referred to a larger bench now. Or otherwise, suppose I'll dismiss it and he will file an SLP, get it tagged and get the relief. Better that he should go to trial court and get it. And that process, you are harassing the accused.
That are completely
That in that process.
the complete case study would not with me, my lord. But whether in the meantime charge sheet is submitted or not, that is that.
No, simply you
I'll take
answer only one thing.
Simply
Chemical
answer,
analysis
take
report,
instruction.
have you filed or not?
Well,
Along with this preliminary, so-called preliminary.
that is not there, my lord.
Then he is entitled. He will go
And,
and apply
After one opportunity given, my lord, next week I will take instruction.
on 9th.
9th, my lord.
On 9th.
Whether it's a final charge sheet or
You get on 9th. But I'll
my lord.
what I'll do is I'll relegate him to the trial court for applying regular bail, and I'll keep this question open.
Well.
167(2) question open to be decided by the trial court at the time of grant of bail. In view of that Supreme Court judgment.
Well.
You get that judgment also. 9th, huh?
My lord.
9th. Item 12. 12 is done. 11 is done. Achha.
May I please, Your Lordship?
My lord, the petitioner challenged the rejection of recalling the petition of TW1, who is the informant in the case. Offense is under section 302. My lord, here the petitioner has filed a petition.
311.
Yes, ma'am.
Yes. What happened?
My lord,
Rejected.
Yes, my lord.
The rejection order.
My lord, that is page number 30, annex 5.
Why?
My lord, on the ground that, my lord, the petitioner has been, the PW1 has been declared as the hostile witness by the prosecution. After cross-examination by the prosecution, the section 154 petition has been filed by the prosecution on 5th August 2023, but the petition has been solved on 8th August 2023. But the witness has been declared as the hostile witness on 5th August 2023. Therefore, the conducting counsel of the advocate has not got knowledge about the regarding the witness examination matter. Therefore, my lord, he has filed a petition for recalling of.
No, you are asking for recall of PW1
Yes, my lord, PW1.
who has been hostile.
Yes, my lord.
Why you are trying to recall him a hostile
my lord.
witness?
Because, my lord, though he is, my lord, hostile, my lord, there are certain line has been deposed by the witness, my lord, against me. Therefore, I have filed
Where is that statement?
my lord, that is in certified because, my lord, I have page paragraph number 7, my lord. Here is submit.
You have not filed that.
No, my lord. I beg pardon, my lord.
Show me the record.
Paragraph number 7.
You have a copy. You better you file it. Place
Yes,
it
my
out.
lord. I will file an affidavit.
Place it out.
Yes.
But don't you bargain risk by inviting a hostile witness?
My lord,
For one sentence
yes,
or
my
two,
lord.
you
Yes,
have
I know, my lord, I know
witness
their
who
situation, my
who
lord.
is hostile.
Yes, my lord. I know their situation, my lord. But there are certain statement by
Read that statement, how it
My
is
lord.
harmful to you.
Yes, my lord. The incident took place on 20th September 2022. At that time, I was staying at Bhubaneswar with my mother. Whatever I have stated today was as per the say of the advocate of my father, who is the accused person, my lord, petitioner. Rahul Bhai has scribed the affair as per my say, and IO has examined in this case, and my family had no bad relation with Sunita, another witness, my lord. My lord, that is one thing. And in paragraph number 3, my lord, that is another thing here. After death of my mother, we brought the dead body of my mother from SC Medical College to Bhubaneswar. Thereafter, we took the dead body of my mother to our native village in the district of Kandhamar. We are not visited any police station at Cuttack, and no police has examined me at Cuttack. And we had taken the dead body of her mother to Hisramunda Basti. I have not informed the local police about the death of my mother. Police personnel has not examined me at that time, my lord. Relevant part is the, my lord, paragraph number 7. He has stated that I have deposed as per the persuasion of the advocate of the accused person. He has deposed. Therefore, my lord, we have framing certain questions, and by giving certain questions, we have filed that petition, my lord.
Where is that question?
My lord.
You place that statement, the statement which you have, statement of the hostile witness. You
Yes.
place it on record,
My lord.
and we'll see that.
Copy also short.
Supply
I'll
the
no.
copy.
I'll file an affidavit, my lord.
Next week. Next week.
I may be pardoned, my lord.
But still, it is dangerous proposition for you.
No,
That is your wisdom. We can't say that, but still, think over it.
I beg pardon, my lord. The case has been posted to 6th
You
December.
seek adjournment.
Yes, my lord. On last day, my lord, that order has been passed. If I will file a time petition, then
You seek adjournment, no problem.
my lord. Therefore, kindly, my lord.
Is there any order to that effect?
Yes, my lord. On last night, my lord.
I will simply
If I
adjourn
file
it.
a petition, then the case may be adjourned.
The petitioner is directed to place on record the testimony of PW
1 minute.
PW1 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 on record. PW1 on record. He submit the land counsel for the petition submits that the trial the next date of hearing before the trial court is
6th December 2020.
6th December.
January.
Huh?
6th January 2022.
Come on 5th.
Yes, ma'am.
Come on, forget. Cut it on 5th. Now orders, huh? Fresh matters. Completed. Pass over. Item 3. Yes. Kitna pass over? Yes. What to do? The first call he was there? Nobody was there. At the end, February. First call he was not there?
He was there.
He was there.
Day
Next
after
week
two.
or next week?
Day after 2.
Item 7. That's the problem. You have to follow a procedure because he was there in the first call and he might have gone to attend some case. You were not there. And nobody knows when it will be called.
But it will be better at up to.
So there should be a pattern in the court.
After
So everybody will know
2
that
PM वाले pass matter से taken up.
pass over after 2 o'clock. इसको दोबारा pass over. I don't call pass overs. At 2 o'clock. All pass overs in 2 o'clock. So that it is easy. Everybody knows. Once it is pass over, it will be taken up 2 o'clock. Item 13.
I'm there in item 9.
Pass over at 2 o'clock. Pattern.
Process should start tomorrow. It
Okay.
has to be retrospective.
कल start करना है तो आज करना है.
As your lordship. But I was there in 9, my brother is there for this day.
You come have lunch and come fresh.
Morning is more fresh.
Now what happens is if you call obnoxiously like this, there is a likelihood that
The morning is much fresher than the afternoon.
no, after lunch is much fresher for me. 13. Yes,
Yes, madam. For me to withdraw this.
withdraw.
For me to file better.
Memo, have you filed memo? Take on record memo and withdraw. Next, 14. Item 14.
May I please, your lordship?
Yes.
So that address statement has to be filed, my lord. I undertook to file by tomorrow. Address statement could not be filed.
Which statement?
Address statement, it has been noting there the address statement of the has not been filed. I filed the requisites, but address statement has not been filed. There is a noting in the cause list, your lordship.
Then you file it.
We'll file it by tomorrow.
Simply adjourn it.
No, I file it tomorrow. But my lord, I have moved an IA also.
Oh, what is that?
If your lordship will see the first order,
Flag?
the first order, order dated 14th of February 2023, your lordship.
14.
My kindly have a look on that.
Yes.
Paragraph 5 onwards. Mr. Kanwal and senior advocate submit that with the self-same allegation, the informant lodged and complaint before the Delhi police.
Where are you reading?
The first order of
Yes,
this
yes. Para 5.
Para 5.
Yes.
Mr. Kanwal and senior advocate submits that with the self-same allegations, the informant lodged a complaint before the Delhi police, which is pending investigation file containing. So he refers to the annexure 6 lodged in the year 2020. The translated copy of the FIR is submitted before the court. It is contained that in the investigation of the similar allegation pending in Delhi police, the FIR is the informant is not tenable in law. So UAW PS is concerned. It is submitted that the petition has also lodged an FIR, the petition here, against the informant as they had some business transaction. Submitted that by the learned senior advocate that due to the efforts reason, the present proceedings pending before this honorable court below city case number so and so should be
Should
stayed.
be stayed.
Considering the above facts of the Congo, this court is inclined to direct that proceeding before the learned AMC is connection with city case number so and so has been stayed. My lord, I moved an application because your lordship will know that the similar allegation, only the amount has been increased and filed another FIR in the state of Odisha, increasing the amount. So therefore, it comes within the purview of OW case, your lordship. There the amount was 90 lakhs. Here the amount has increased 1.17 crores. So therefore, it is coming under.
Right.
So therefore, we brought for this one report.
And you got a stay.
So,
Investigation is stay.
Investigation upon my lord,
Yes.
upon my lord. So I moved an IA, my lord, that to give the direction to the state that to get the status of that proceedings before the Delhi lordship.
You are the accused. They will do everything for you.
My
Thereafter,
lord,
you will say that you.
my lord, what has happened? There the case is closed.
You should.
No, no, there is
the
there is
FIR in Orissa is concerned,
Huh.
you got a stay. Be happy with that.
No, my lord, there because the
They should
police-
have by now. They should have challenged saying that this
they-
order.
no,
saying
they-
that investigation.
but
could not have-
that affair has been closed. There the no question.
File it.
File it.
You get it and file it. Why should the state will be burdened to get something for your this
Because
thing?
I have got a notice. I have annexed in the IA also. There's a notice has been issued to one of the.
Now everything is online. You can get it in Delhi. FIR and charge sheet. Everything you get in online.
My lord, I will file the red statement. My lord, interim order to continue till the.
Interim orders to continue, and he will cure the defects.
My lord, my lord.
And it should be since this is state. The investigation is state. Let it be urgent to February. By that time, everything will be.
My
February end.
My-
February end.
My-
So that by that time in Delhi.
I will get it. I will file it.
Charge sheet and
My-
everything.
my- Interim order to continue.
Interim order to continue.
Mana urgent to
Develop.
February.
February.
26th.
February. By that time, Delhi investigation, he will come to know about.
If notice will go, my lord, the informant will appear in this case, my lord. Notice, my lord, due to my lord, address, my lord, proof, my lord, address statement, but for that notice could not be.
That he will do in
I'll do it by
course of the
tomorrow.
day.
I'll do it by tomorrow.
That
CD
during the course of the day, he will cure that.
I'll do it by tomorrow, my lord.
Tomorrow, by tomorrow.
My lord.
The defect.
Deeply obliged.
Item 15.
May I please, your lordships? Here, my lord, the petitioner challenges the criminal proceedings against him. The petitioner challenges the initiation of criminal proceeding for the Alice Commission of Offence under Section 506 and 294 of IPC, my lord. Initially, FI was lodged, my lord, by the complainant, my lord, for the Alice Commission of other offences, including 506 and 294 IPC, my lord. After charge sheet, my lord, police submitted charge sheet for the Alice Commission of Offence under 506 and 294 of IPC, my lord. The offence under Section 506 and 294 are not at all made out, prima facie not made out against the petitioner, my lord, for which the 482 petitioner was filed, my lord. And by order dated 5/5/2003 to 2023, this honorable court granted stay order, my lord. Subsequently, basing on the judgment, ACN resurfacing, the stay order was automatically vacated. In spite of several memos filed by the petitioner, my lord, this matter could not be listed before this honorable court. Thereafter, my lord, I would like to bring your lordships to statements which reveal that prima facie offence under Section 506 and 294 are not at all made out against the petitioner.
Charge has been framed.
Charge has been framed, my lord.
You are challenging the charge order.
Initially challenge the initiation of proceeding, and by that time, my lord, charge has already been framed.
Kindly have a glance.
Now, what are you challenging here then?
Challenging the proceeding.
Now, since charge has been framed,
Yes, ma'am.
that order you have to challenge.
That charge order had been challenged in the revision, my lord. That has been dismissed, my lord.
But I am
This is-
giving that order, my lord. My lord,
This is infractuous now.
after charge was framed.
Revision of number.
After charge was framed, what he says is he got a stay in this 482. because of that Asian judgment,
Well, that was
it
also
was
stayed in
vacated.
another revision.
And meanwhile, charge is framed. He filed revision and revision is dismissed. Then
Yes,
remedy,
well.
you have to follow that remedy, not infractions.
That remedy already over, my lord, because that is
But
under
whatever, this is
401, my lord. Power under 401 is limited, my lord, but so far as the power conferred to your lordship under 482 is vast, my lord. And inherent power, inherent.
It is not so
Your
fast
lordship-
that in a infractious petition also some order can be made. This petition is infractious.
No,
After
my-
charge is framed. So in an infractious petition, how can 482 can be exercised?
in view
Because
of
you have availed the remedy of revision against the framing of charge.
but
You lost
by
there.
the time, my lord, by the time this
Then if I'll pass any order, then I intend amounting to reviewing that order of a coordinate bench. Passed in a review jurisdiction, revision jurisdiction. How can I do that? Suppose I am agreeing with you. What will I do? I'll have to alter the charge which has been confirmed by the revision court.
because by the time this
You
482 petition was admitted, my lord, by that time
you have a
charge has already
point.
been
You have a point because see, but the whole difficulty is this. Now you
I cannot solve that.
catch 22 situation for you. We'll dispose it up and follow that remedy. Take it further. Wherever remedies are there.
Because the remedy lies only in 482, my
No,
lord.
no.
Yes, my lord.
After revision again remedy lies here.
Revision against order dismissing the discharge petition.
But that is not assailed here. It was in the initial stage you have challenged this. You file a fresh one, we'll see. Fresh one. Where is that order of stay?
Order of stay 5/5/2023, my lord.
Where is that order? You have placed it?
Order number 3, my lord. Order number 3.
3, okay. No, the stay order of
Right.
this court.
Yes, my lord.
Stay order of this court is dated. Write down.
It was not for a definite period. My lord. It was stay order was not for a definite period.
I have given the photocopy of the order passed by this honorable court in criminal division. And I have glass to.
That revision petition. Give me,
Yeah.
give me that.
Paragraph 7, by the time CLF is filed in the year 2020.
20.
Yes.
And the chart, kind of glance, the order passed by this honorable court in criminal division.
Yes,
Paragraph
yes,
7.
7.
Order counsel for the
Let
state and
counsel for the state inform.
so the charge was already found on 7/12/2022. By the time the CLF should file, by that time charge was filed, that order was not challenged. And in the meantime, discharge petition was filed, that was filed. At the time of cognizance and so offense is made out. For the time, and the charge has discharge petition was dismissed, and the charge was framed,
Right,
that has been
okay.
confirmed.
The petitioner in this petition has petitioner has invoked the jurisdiction of this court under section 482 CRPC, seeking quashing of the criminal proceeding pending before the JMFC so and so para page 5 so and so in GR case number 71/2020 so and so. Also. When the matter was taken up on but this stay order was passed on 5/5/2023.
My lord. And there was no definite period, my lord.
No, 5/5/23.
Yes, my lord. Soon after expiry of 6 months, my lord, the learned trial court went on
Initial stay was granted in
5/5/23, my lord. 5/5/23.
the 5/5/23. Then how Asian judgment will come in your way?
Yes, my lord.
Huh?
Soon after expiry of 6 months, 5/11, my lord, the learned trial court went on fixing the date after 2 days, with the interval of 2 days, 2 days, 2
Sure.
days, my lord.
Right, okay, what I will get? Okay, This petition was filed on 8/2/2023,
My lord.
but that time charge was framed.
Yes, my lord.
You have not
At all.
informed this court.
My lord.
Have you disclosed that charge has been framed? In this petition, in this petition,
I have filed the order, my lord, and it's 3 mile. 2. Copy of order 7/12/2022, my lord. 8/12/3/1/22.
yeah, file complete.
Case 22, my lord. Order
20?
dated 7/12/22. That is being informed, my lord.
We will not go into all this. Telika? It appears from the record that on 7/12/2022, the Land Trial Court has already framed the charges against the petitioner for offence under section 294/506 IPC. Next. Assailing the said order dated 7/12/2022 passed by JMFC Kudunluguma. The petitioner filed criminal revision CRL REB number 633 of 2023. The
Not against that order.
Cabinet bench of this court, while this order dated 21/12/2023 has been pleased to dismiss the revision petition, confirming the order of framing charge by the learned trial court.
Pardon, my.
Also, in view of the aforementioned development in the internet, the present petition is liable to be dismissed. Accordingly, the criminal miscellaneous क्या नंबर था इसका? CRLMC number 733 of 2023 is dismissed.
Order dated 23/11/2023 is under challenge in revision. Filing discharge petition after charges paid. Paragraph 3 man can. So that.
This order was not challenged in revision, my.
Paragraph 3.
Paragraph 3. Order dated 23/11/23 challenging the discharge petition which were dismissed by the Lord Judge. The challenge which was
No, charge was framed on
7/12/23.
7/12/23. Against the charge only he has come. Charge and removed and discharge application.
Mine
Appearance लगा.
appearance of the
Informant.
Please, your lordship.
इसको पेन ड्राइव में रखना. Pen drive में पेन ड्राइव. Yes. Yes.
My lord, some defects have been observed. 2 weeks time may kindly be allowed.
2 weeks to cure defects.
Obligation.
2 weeks time granted for curing defects. Next.
19.
Yes.
Item 17.
Wanted to withdraw.
Memo.
File report.
You have the Vokalatnama with you? You have, your Vokalatnama?
Yes, sir.
Mr. Sushant Kumar Tripathi, General Counsel for the petitioner, seeks to withdraw the present petition. Next product. Petition is dismissed as withdrawn.
Item 18.
On instruction, Mr. Sushant Kumar Tripathi. Yes.
Item 18.
Pass over.
Item 19.
That is reliance file. Where for direction for early disposal of ST case number 53 of 2022.
Use the mic.
My lord.
Ah.
My lord, the petitioners are the accused.
Mic is on?
Yes, my lord.
Yes.
My lord, the petitioners are the accused persons.
Yes.
And,
How many of you are there?
3, my lord.
3 of you.
My lord.
Okay.
Early disposal of the ST case number 53 of 2020.
Early disposal.
My lord.
When the charge sheet was filed?
My lord, charge sheet submitted on 26/9/2020.
2020.
Yes, my lord.
What is the stage of trial?
Charge has not yet been framed.
Yes, sir.
Yes, 17/11/2022, matter has been posted for consideration of a charge.
Whatever, to 2020,
Yes,
today 3 years, no charge is framed.
yes, sir. Yes.
What is the problem? Which is the court?
The councils are taking times, filing 317 petition. You'll also may kindly turn to page 13.
13, huh?
Page
If
13.
see, if the delay is attributable to you, no question of show me.
13, you'll also may kindly turn to 13. Page 13.
13, yes.
13. Since you'll also may kindly see how many dates they are taking. Going on taking dates, 16/8/2022.
Accused persons are allowed 317. Accused person 322. Discharge application. Discharge application was moved on later, on the same day. That is on 2022.
And later on put up on the desk fee for objection. Then at 17/11/2022, again this court was suspended due to demise of an advocate. No steps taken to 4/1/2022 for consideration of charge. Then 4/1/2022.
Still, I'll just give an observation and finish up.
Yes, ma'am.
In the present case, the FIR was lodged on 15/5/2020 under section, write down every section, page 6, against the accused persons, namely the petitioners. Subsequently, after investigation, charge sheet was laid down by the investigating agency on charge sheet.
Charge sheet date code.
Charge sheet को file
26/9/2020.
26/9/2020.
26/9/2020. Page 11.
2020. 2020. And Land Counsel for the petitioner submits that despite the fact that the charge sheet was filed in year 2020, charge has not yet been framed. Therefore, he has approved this court under section 4, invoking the jurisdiction under section 482 CRPC, seeking a direction for targeting the trial. Seeking a direction for expeditious disposal of the ST case number 53 of 2022, pending before the Court of Learned ASJ, Nimapada, arising out of GR case number 206 of 2022. Perusal of the proceeding sheet annexed as annexure 2 to this petition indicates that the accused persons have been taking liberty of adjournment in one pretext or the other. One pretext or the other, and eventually they filed a petition under section 227 of CRPC seeking discharge on 26/9/2022. Therefore, the delay appears to be attributable to the petitioners. Having said that, it is the constitutional right of the petitioners for speedy, fair, free, fair, and speedy trial. Therefore, the prayer made in this petition regarding the expeditious trial needs to be addressed at this stage. Next paragraph. The petition is accordingly disposed of with a direction to the trial court to do good, to see that the trial is concluded expeditiously.
Yes.
However, it is made clear that the petitioners being the accused are duty bound to cooperate with the trial, without fail and without seeking unnecessary adjournment.
Yes.
I think
20.
What is happening, Mr. Mishra? Every time you file and withdraw?
Metro is not listing in spite of filing.
Now it is listed, argue.
Impetuous.
Now it has been in process.
Withdraw.
Okay.
21.
Yesterday also you withdraw one petition.
Yes, that is the problem. In spite of filing repeated memo violence, matter are not listed. When the matter is listed.
Yes.
21.
Yeah, please. The petitioner before lordships for questioning for the prayer for questioning the criminal proceeding, entire criminal proceeding on the ground that the informant is also her husband. They have deposed that they do not want to proceed with the case. Page 13,
13.
Page 13.
Yes.
Page 13, my lord, the complainant. I am the informant in this case, but I do not know the accused person standing there. Dispute has been amicably settled.
Where are you reading?
Page 13, man.
Okay, I am the informant in this case.
The dispute has been amicably settled outside the court, and I do not want to. I do not wish to proceed with the case. And the
yes,
my lord, also the
Not supporting.
Where is the? You can file a joint petition and finish it up.
Yes.
already the position has.
The person, other witnesses are there.
But the other witnesses may be there. What is
Her
the offense?
husband, my lord, deposition number 2.
What is the offense?
Offense, my lord, 419, 420, 379.
And the bank officials are the main persons. Because they are the entire case depends on the evidence of the bank employees. Because the transaction made through the bank, somebody has opened an account in favor of the petitioner and a sanctioned loan, obtained loan, and that loan amount has been taken away.
No, my lord. Fact is that I am.
That he has stated.
Who is this witness then?
My lord, he is the probationary officer. One officer of who.
You are a probationary officer.
My lord.
Yes.
Another person, 3 accused persons, my lord. Another person, 4 accused persons. One person was appointed in the bank to motivate the customers, those who have much amount of deposits, to invest in mutual funds. He is the principal accused. He, along with another person, made conspiracy by the way, change the mobile number where the role of the petitioner has only, as they have requested to change the mobile number, the present petitioner changed that number. Thereafter, all the mistakes done by the other accused persons. The petitioner has not have a single amount to his account or to him. All the money that has been they have transferred to their
But there
account.
must be, the charges must be 120B also.
My lord, 419, 420, 379, 34, 66C.
34 is there.
66D.
The moment we cross, insofar as this accused is concerned, the other accused will also come and say that it's crossed.
Exactly, bro.
That problem is there.
This
The
is
bank,
In respect of this accused only.
Had it
the
been a
moment I
case of,
pass the order and that will be annexed and subsequent petition.
but had it been a case of individual concern,
Individual hai, why cannot?
then matter would
They
have
are
been
not the
different.
bank officers.
It is a
They
case
are
relating to the
they are
bank.
the private persons. They have
Who is this informant?
informant is the depositor, a customer of the bank.
But he has stated in FAR in page number 10, he has stated somebody has opened an account in my name, obtained loan, and that amount has been taken away.
Okay.
My lord.
So it's entirely depend upon the employees of the bank. Apart from that, the other persons, those are 120B.
Just the investigation showed that. My senior is saying that opened an account. That is not the fact. Only the mobile number was changed. Account was.
No, see, charge sheet, let us see.
Charge sheet.
No, he will also try to help you out. If any problem is there, then only will not do. Otherwise, there is no problem.
But it is.
But we will have to examine it. What is the cost-cutting effect if the other accused persons are not there? Suppose you allow it, the other accused person will come.
That is the main problem.
But they are not the bank.
So don't think that he is opposing. He is only trying to find out ways to help you out.
Investigation actually account ta khola hayni. Ta mobile number ta khali change heji. Se sethru jo message jautula se asi gote other bank re jaki pacharla to mo mobile le kahi kichi message asuni. Thereafter the bank manager of
mobile number ta change kala ki
the present petition. On the
kahi kala
under what on the request of the that officer who was appointed in the bank to pursue the persons to invest their money on the mutual funds. He has a seat on the bank.
He is the manager.
Present petitioner is the provisionary officer.
You'll also go through the charge sheet and then you'll also decide what can be done in better.
He must be a young officer.
My lord.
Let us see if anything can be done because his career will be ruined.
Yes,
It is a small mistake, only the change of mobile number.
Yes.
Why to
only rely
Proceedings, my lord. I'm always in favor of that petitioner because he's innocent. Even if accepting that for the sake of argument. But the question is that the other accused persons, they will come.
Therefore, we have to carefully
They will
see
come
that.
up. They will come up and they will plea that taken plea.
They are the main. What is the allegation against them?
They have taken the money. They have returned to the police officer.
So, no,
everything is against them.
His evidence is most important because he is to say how he is connected and how what evidence is available with him because he is the employee of the bank.
No, I am admitting that.
I am reading two lines. That creates some difficulty.
Where are you reading?
At the page 10, Miller. Page 10, 10.
Yes.
You
should have converted him to an approver.
Yes. Seটা ଟିକେ ଦେଖନ୍ତୁ Lordship kindly see. ମୁଁ ଏହା ଜଣାଉଛି କି ମୋର FD account number.
Second paragraph.
नहीं first paragraph third line.
निवेदन
ଜଣାଉଛି କି ମୋର FD account number so ରୁ କେହି ଜଣେ ଅଜଣା ବ୍ୟକ୍ତି ମୋର ଅଜାଣତରେ OD କରି ଗତ ତା 18/2/2021 ଦିନ 22,50,000 ଟଙ୍କା ଲୋନ ସାଂକ୍ସନ କରାଇ ସେଥି ମଧ୍ୟରୁ 18/2/21 ଠାରୁ ତା 12/4/21 ମଧ୍ୟରେ 13,74,537 ଟଙ୍କା 54 ପଇସା ଉଠାଇ ନେଇଯାଇଛି। that makes my lord.
Loan sanctioned the loan, came
It's a
to the
problem.
account,
No,
withdrawn and taken away.
ସେଇଟା problem create କରୁଛି.
Who is the sanctioning authority?
No, the petitioner is not. My lord, I am going through the charge sheet, my lord, pass any order. But not except the changing the mobile number on the request of the officer who was appointed to for motivating the persons to invest in mutual fund. The petitioner is not.
What is the stage of trial?
My lord, we have deposed the petitioner, the complainant and her husband. The complainant and her husband.
See, I am sure that on the basis of this evidence which you have placed at page 13 and all,
My lord.
you will be acquitted. Definitely.
May I suggest, my lord, one thing?
My lord, just before some seconds.
What we'll do is, I'll tell you, what
Yes,
we'll do is,
yes.
instead of invoking 482 in the state, I'll expedite the trial and
Exactly.
put it for
My lord,
3 months.
my lord, just before few seconds, your lordship state that the bank officer is a young person.
That is why 3 months. Otherwise, I would have done 6
Yes,
months.
exactly.
Because see, the evidences are such. you
Sir,
will
a
be
problem
acquitted.
create. It will create problems.
It will create problem because the other accused persons
Other
are there.
accused persons
So
are there.
I'll see how many witnesses are there. Let
Yes,
us-
we will also with charge sheet is the.
Let us see how many. How many witnesses there are? 22 witnesses.
Huh.
Yeah. This witness is number
1 and 2.
1 and 2.
1 and 2.
They are the informant.
informant.
You tell me how much time will you take? 3 months will do or 4 months?
3 months time ଦେଲେ ବି ସେ କରିଦେବେ 4 months କରନ୍ତୁ
Organ to young.
ଆଜ୍ଞା 4 months କରନ୍ତୁ 4
And
months
only
କରନ୍ତୁ
for that reason, I have before your lordship.
4 months. 4 months करके trial खत्म कर दे.
करंतु.
You will be acquitted. See, there is nothing.
exactly madam କରନ୍ତୁ
Why unnecessary?
ଏଟା କଣ
4 months कर दो. हाँ?
I would take the question, my lord, ଯଦି ମୋ senior ଟିକେ instruction ନେଇଯାଏ ତ କେତେଟା ହେଇଯାଇଛନ୍ତି next week
ଆରେ
Monday
ସାକ୍ଷୀଟା ଆପଣ instruction better ହବ ନା ମୁଁ କଣ
नहीं ठीक ଅଛି. He is also correct there.
no he is the
There are
conducting
22
counsel
witnesses.
ମୋଠୁ better ଆପଣ ନେବେ
नहीं, there are 22 witnesses.
yes yes
You just seek instruction. How many witnesses are really witnesses to be examined by you? You ask your prosecutor.
Right.
22 cited witness. You may not examine 22.
I am not the
You may examine little lesser than that also. So just ask. So we can accordingly adjust the time.
I am not the
Exactly.
conducting advocate on this.
You also seek the time. I am putting it
Friday.
on Friday.
Right.
Monday, you also seek instruction.
Right.
How many witnesses are now examined and how many witnesses he will tell how many
Right.
witnesses to be examined. We'll fix the time. Let it be lesser time than. Okay.
Okay.
That is on Friday. Simply adjourn to Friday. We'll do it.
yes ma'am
ଆପଣ ବି ନେଇ ଯାଆନ୍ତୁ ଦେଖନ୍ତୁ ଯଦି ଏଭିଡେନ୍ସ କରିବାର ନାହିଁ କିଛି
ହଁ
after these witnesses have been examined main
Right.
witnesses if you don't want to proceed immediately will fix little lesser time and finish the trial
right
ठीक है
22 kindly pass over my lord.
pass over
Okay. 23
pass over
24
withdraw you have memo take the memo and withdraw 25
This is a matter arising out of the rejection of 205 application of the petitioner, my lords. My lords, in the meantime, there's a Odisha High Court video conferencing rules, my lords, which gives the accused the permission to appear through VC. So, my lords, I'll apply in terms of that rule, my lords.
what is the offense
Offense is under, my lords, offense is commitment, the maximum punishment is life, my lords. But I have all the licenses. The allegation against me is that one of my associate who has left my unit has opened a nearby unit of tobacco manufacturing, and the allegation is that I am involved in that unit. I have all the licenses. The only allegation is one of my ex-associate. He has left me since last 7 years, and he has opened another manufacturing unit which is adjacent to my.
where is the
Godown.
trial happening
It's in Barampur, my lords. And
You
this
are-
petitioner
you are
is
stationed
residing
where?
Bhubaneswar. He used to stay
you
in.
want to
Baram-
continue where continue committing crime and keep on appearing in VC in all over.
No, my lords, it's not like that, my lords. The present petitioner,
Show
my
me-
lords,
show
he
me
was
the
in
rule.
Barampur.
Show me the rule.
My lords,
That is
rule,
permissible, why not?
my lords, that rule I don't have, my lords. That rule is there, my lords.
Pass
Lordship
over,
pass o-
2
passes
o'clock.
over.
2 o'clock. Come with
Grateful.
the rule and we'll dispose it.
Before that, my lord, your lordship may, he should prepare to say and satisfy before your lordships. If many applications have been filed before this Hon'Ble Court, so far this petitioner is concerned, why no certificate has been given? No certificate has been given.
Many applications with refer to
How many
failed
applications you have filed?
Those are separate.
CRLMC, many applications.
What are
Separate,
those?
separate offenses, my lord.
What separate offences?
So that he might have committed many offences.
Your lordship may kindly see CRLMC 593 of 2006.
No, insofar as this FIR is concerned.
So far the petitioner is concerned.
Petitioner has 7 FIRs against him. This
Arre,
is with respect
ଆପଣ
to one
PS
crime.
case number ଟାକୁ ମୁଁ ମାରିଛି ଏତିକି ବାହାରିଲା
Let's take
ଏଇ PS case
instruction.
ମୁଁ ମାରିଛି PS case number 6/2016. These are the applications which have been disposed of by this Hon'Ble Court in the since started from 2016 to 2017.
Let's take instruction from the conducting.
And you have given
Then I am adjourning.
you have not given any certificate.
My lord.
You never know.
My lord.
The client might have not
My lord.
instructed you.
Yes,
My lord, my adjourn it to
but
next week.
Same
my lord.
prayer might have been made and rejected also.
No, no, this is the first time the 205
And
application.
if I am
He
not
might not
wrong,
have given you instruction.
if I am not wrong, this is item 25
25.
and accused is P. Gopal Krishna.
Gopal Krishna.
Right.
Ah.
This is right. Mullah.
But he is doing your homework.
My lord,
You should have done it.
My lord, I'll take the instruction.
Fifth.
Fifth, man.
Come with the rule also. Huh?
My lord, grateful.
Pardon your 26. Pardon your lordship. May I pardon your
He is advising without fee. Take it and I know, I understood it. That's what I'm saying. He is advising without fee. You come on Monday, Friday.
Pardon your lordship.
Yes.
Item no 24 on behalf of Mr. Das permitted to
Withdraw.
my lord.
Oh, withdraw.
Item no 24.
24 withdrawn already. Huh?
26, my lord, on behalf of GK Mahanti, may I allow to take on the next week, my lord.
Next week. 27.
27. Husband and wife dispute, your lordship, almost resolved. Almost, why it is resolved? I have paid the permanent alimony. I am the husband. Documents have filed. Divorce has been granted. Page 17, my lord. And she has also given an undertaking affidavit before the trial court. Page 15.
Bring her tomorrow.
Notice जाओ.
ଆପଣ ସେଟଲ କରନା ଡାକି ଆଣିବେ ସାଙ୍ଗେ ସାଙ୍ଗେ କାଲି ଆଇଟମ 2 ରଖିବା କରିଦେବା ଖତମ
ନାଇଁ ସାର୍ ସେ କୋଉଠି ଅଛନ୍ତି ମୁଁ ଜାଣି ପାରୁନି
ଦେଖନ୍ତୁ
ଅନୁଗୁଳ ଆଡ୍ରେସ ଅଛି but
then make it day after tomorrow first item
let notice go. I'm not asking for anything. Let notice go. Your lordship may keep it after 15 days.
Why 15 days?
I don't know her whereabouts.
But you have settled.
Your lordship. Your lordship. As a lawyer, I don't know. Your lordship, everything is there. Page 15.
No, Shanti Agarwala.
Shanti Agarwal. My lord may look at page 15.
Angul.
Angul.
Chalo, issue notice to opposite party number 2. Returnable requisites. You file requisites. Returnable. ଆପଣ କୁହନ୍ତୁ
ଆଇଟା ଅଛି ତ further proceeding is fair.
Stay ତାହେଲେ ଅସୁବିଧା
settlement ହେଲା further proceeding.
No, that will be not in this. I have filed.
That's what I'm saying. Come tomorrow, second item, or day after tomorrow, first item. Bring her. I'll quash it here right now.
How sir? 15 दिन ପରେ ଆସୁ.
Or let she appear through a counsel. Or file a joint affidavit before the concerned police station. That also I am ready to do.
That I have already filed.
No. Police has to verify. Impersonation.
Nice, sir. Court file my lord. Page 15.
15.
15.
Section 3.
It all first page ta accused persons. Second page.
Now the settlement taken place in the mediation.
Matter was pending for my lord before the family court. There.
No, under the Mediation Act it has been settled or what? If the Mediation Act it is settled, I will quash it here.
Not under Mediation Act.
Because in the new Mediation Act, if it is settled, then we can quash.
She gave a compromise petitioner's file. She says, for which the informant does not want to proceed with the case any further and wants to withdraw the case. It is page 15.
That application filed before the London SDGM.
SDGM. It is compoundable. No, that's why the problem SDGM. Even otherwise also, let formally notice go to her so that your lordship, even if she
Let-
doesn't appear.
Let issue notice to the opposite party number 2. Land Council for the state is also requested to seek instruction from the concerned investigating officer. For the case number କୋଉ ନମ୍ବରଟା କେସ୍ ନମ୍ବରଟା ଆପଣଙ୍କର
କେସ୍ ନମ୍ବରଟା ଥିଲା ସିଟି 228/2006
କୋଉ ଥାନା କୋଉ ଥାନା
ଏଟା ସିଟି ଟା
City 2228 of 16.
ନାଇଁ ପୋଲିସ କେସ୍ ଷ୍ଟେସନ
କୋଉ ଥାନାରେ
ପୋଲିସ ଷ୍ଟେସନ ନମ୍ବର
Mohila PS. Bhubaneswar Mohila PS.
ମହିଳା PS
ମହିଳା police IO instruction regarding the settlement between the parties in the instant case. We have issued notice. He will seek instruction from the IO. If the IO also comes and says that they have settled, we'll quash it. Put it on no next week 10th.
notice ଟା 10th ରେ ଫେରି ଆସିବ
Well, he will do it.
କାଲି
Take just the
exemption petition ଟା ଅଛି original certificate copy of the
exemption allowed.
28.
Dusty as well, huh? Dusty as well. File 2 requisite.
ଜାଣିନି address କୋଉଠି ଅଛି ଜାଣିନି ଯାଉ ଆଜି ନେଇ ଯାଉଛି
ଆଜି କରିବେ।
My lord, on behalf of Mr. Lalitendu Mishra, I pray for a passover, my lord.
Password.
29.
Therefore, Mr. Anuruddha has kindly taken up the matter after 1 week.
1 week.
30.
My lord, initially the FIR and lordship will see under annexure to page 20 was filed under sections 3, 4, 5, 6 and 7 of the Immoral Trafficking Act. Now your lordship may kindly turn to page 11.
11. Yes.
Order dated 4/6/18. I was arrested and was released on the bail by the learned SDGM Bhubaneswar. Thereafter, charge sheet was submitted. Your lordship will see annexure 3 at page 25. 3, 4, 5, 7 of the Immoral Trafficking Act and 373 and 370A subclause 2 of the Indian Penal Code. Now, my lord, as I was on bail, after the charge sheet, I have to again go seek the continuation of bail. What the court below has done, court below has taken cognizance and issued summons. Now what will happen? SDGM cannot grant, once he has granted bail on other provisions, and the additional charge, he will not grant bail because 370 is to be tried by the Land Court of Sessions. So my problem is that I was on bail. Now again, if I surrender, I will be put behind bars. And 370 is not, 370 or 372A2 is not made out because once I'm arrested under the Immoral Trafficking Act, being on the place where the Immoral Trafficking Act is, immoral activity is there, 370 will not be applicable. That is my humble submission before your lordship. So if that previous bail is continued, my lord, it's well and good. I have nothing to say. But once this additional charge is there, I have to resurrender and have to seek a fresh bail because that bail was on 3-4 sections. This is an additional section which has been added. That is my problem.
You see 438.
Well, 438 at this juncture will not be applicable because I am already arrested and put behind bars.
So far as the additional charges
Only
are-
the provision is 438. Because
Additional charges
there
are-
is change in circumstances, so
simply
far the
adjourn it.
offences are concerned.
Try and get it.
My lord, what I was praying before your lordship, subject to your lordship's kind consideration, that I will surrender and be released on bail and I will face the trial because this is an additional. And your Honorable Apex Court has been saying once bail is granted, it will continue till the end of the trial. And I have been on regular bail. I mean, I was arrested and was granted bail. Not that I was on anticipated bail. I was on a regular bail.
But it's an aggravated offense now.
Yes, that is the problem. My lord, SDGM now cannot. He will simply put me behind bars. Again, I have to face that problem of coming to court. Again, I'll be moving.
But you can maintain a 438 petition on the aggravated charge and seek anticipatory bail. Why are you so apprehensive about not getting?
No, I am now on the ground before your lordship that 370 is not material is not made out.
You show me, you satisfy me
Yes.
that 370
Your
is not
lordship
made out.
kindly see the FIR.
Insofar as the surrendering, getting bail and all, this is
Your
not
lordship may kindly
our
see the
jurisdiction.
FIR. Your lordship may kindly see the FIR at page
Yes, page
22.
22. Okay.
On this today at about 2:30.
I don't think anybody can read it.
My lord, I am giving the certificate copy. I'm sorry, the certificate copy was not filed. Your lordship may see the FIR and the charge.
Is there any defect here?
My lord, defect is that 6 rupees authentication fees and depositing just.
That's the.
No, ignore that.
Yes, tell me, what do you want to show?
My lord, I want to show that the entire FIR is covering 3 sections, 3 to 4 sections. The charge sheet, no new material was found. This was the only material that I was found there in the brothel.
You have been running a spa.
Yes, that is the entire allegation.
Converted to a brothel.
But was converted to a brothel. And I was arrested. And there is no new material that 370 is made out, or 370A or subsection 2 is made out. Because the material is only that I was running a brothel, spa. The basic material has not.
What are the IPC? What are the offense? IPC. What are the additional this thing?
370 and 370A Roman 2.
370.
Lordship 370. I am not on the other section. 370 says trafficking of persons. Whoever commits your lordship, whoever commits an offense of trafficking shall be punished with rigorous imprisonment of a term which is not less than 7 years, but may extend to 10 years and liable to fine. There is no question of trafficking here. They were working in this spa, and the allegation is that they were involved in immoral activities. So there is no question.
Those things, those facts are tribal.
Tribal.
CRPC is na? CRPC.
There is no allegation of trafficking. Your lordship will see the FIR. It's simply that they were running a spa. And because Jain is the owner, the manager was present in this.
This Sessions trial.
No, no, no. Surendra Kumar Mahapatra is the owner of this spa, and Sanjay Kumar Rana, who was arrested from the spot, he stated that he is the manager. He was engaged by Surendra Kumar Rana, who is the owner of this spa. That is, it is written in the FIR.
What about this?
Vikas Jain is not the owner.
And Gautam Agarwal?
My lord.
Gautam Agarwal, what is there?
All 6 months after 2. My lord, this Sanjay Kumar Rana and Surendra Kumar Mahapatra. These accused persons, one is manager, one is owner. Apart from these 2, others are, my lord, involved in the commission of a crime.
Means
they were cut.
Yes, yes.
Then they can't be held responsible for 370.
My lord.
There is no charge against them insofar as 370. There is a spa. Owner is there and the other employees are there. These are the people, those who they were using the spa. And the raid was conducted, they were cut.
Yes.
And if they're caught, the immoral trafficking act, it's all right. But how 370 you will bring?
Because the statement of the those girls have been rescued from that place.
Have they said that
They have
those girls that these people, those who were there with them,
Exactly.
they are the people those who have brought them?
No,
from somewhere.
exactly not brought.
The
them,
owner might have brought, na?
Owner has not brought. Owner
Then-
has not brought. These
and-
people are engaged in whatever mentioned in the charge sheet. They are engaged in. They were found naked with the girls.
They were the customers.
Right. But what the statement
The
of
customers, you can't invoke 370 and 370 capital A for the customers.
But it's a 34
They are
is
the
there.
stranger. They have been using the brothel.
Yes.
They are going and using the brothel. And you can insofar as the owner of the spa is concerned and the other employees, whoever are there, you can charge them under 370, not 370A and 370 so far as the brothel users are concerned. They are the customers. The paid they take service.
Yes.
Unfortunately, on that day they
Statement that I have sent with
Other से statement नहीं.
entire पर अच्छी सबूत में देई entire documents are there.
how will you substantiate these charges against these people?
If there is single iota that I was trafficking, then yes, whatever your lordship or my friend is saying is correct. But here there is no iota of material that I was involved in trafficking. And the FIR is clearly states that.
These girls were from Thailand.
Yes.
It is also said that they have been paid 2,000 rupees each for the sexual act to the manager, Sanjay Kumar Rana.
Yes, Sanjay Kumar Rana.
No, they were the customers.
Well, let me verify actually what is the excess role of the petitioner, because simple the charge sheet says that he is involved in found naked with
When
the.
was the bail granted to you?
সেটা ঠিক আছে।
Still you have to go 438 court.
But
No.
nothing is made out against me. But that 370
That
will
we
not
will,
get.
that we
06
will,
2018.
we will quash it. Insofar as that part is there.
But that much I want.
But still, why don't you go and argue those things in the trial court? I'll keep it everything open.
But now I want.
And section 34 is there.
See, I'll make these observations, go to 438 court.
But that will be little difficult for me because your lordship, I was granted bail on
Yes,
4/6/2018.
write down. Write down. The petitioners have invoked the jurisdiction of this court under section 482 CRPC, seeking quashing of the entire proceeding.
No, I'm only confining to 370 and 378 to me, nothing else. I'm not in.
Quashing of the proceeding in CT case number 2162 of 2018, pending in the court of SDGM Bhubaneswar, to the extent that they have been charged for the offense under section 370
3
and 370 bracket 3 and 370 capital A bracket 2.
370A is prima facie made out.
Right.
So far 370 is concerned,
Yes,
that is. Yes.
I'm not quashing it. I'll
Yes.
just see.
Yes.
Land Council for the petitioner submits that FIR came to be registered on.
My lord, FIR was registered on
Nobody can read it.
9/5/2018.
I have to believe it to be that day.
Your Lordship.
I can't see it, but 19/5/2018.
This is the kind of quality they have supplied.
19/5/2018.
9/5/2018.
Initially, under what have you written? This one. Against them under section 3, 4, 5, and 7 of
6 and 7.
6 and 7 of Immoral Trafficking Act. He submits that they were the customer in a spa where customer in the spa where the brothel was where the alleged brothel was running. They were apprehended from the spot.
Yes.
Being the customers. After investigation, customer. The petitioners were enlarged on bail on.
My lord, 4/6/18, page 11.
4/6/18. 4/6/18 by
the learned second additional session judge Bhubaneswar.
After investigation, now the charge sheet has been filed, adding two aggravated charges of 370 bracket 3 and 370 capital A bracket 2. Full stop. Insofar as these two charges are concerned, it is triable by the Sessions Court. So therefore, the bail already granted to them may not suffice for their liberty. Therefore, he has approached this court, seeking quashing up the two additional charges added to the charge sheet. The Land Council for the petitioners argues that perusal of the allegation and material available on record, no charges charged insofar as 373 and 370A2 is made out against it. Next program. Land Council for the Land Council for the state seeks time to verify the fact on record. Accordingly, the matter is adjourned to 30th of January. At this stage, the Land Council for the petitioner seeks indulgence of this court for grant of bail to the petitioners.
I am saying that the proceedings may be stayed because now
Seeks staying up for the trial court proceeding.
Once, my lord, this will be straight, then my lord,
Trial court proceeding. Trial proceeding. When the court declined to pass any such order, the Council for the petitioners seeks further time to apply for anticipatory bail before the concerned court, insofar as the added two charges are concerned on merit, and seeks adjournment.
Yes.
Adjournment for 2 weeks. In any case, the petitioners have the liberty to apply for anticipatory bail insofar as added charges are concerned. Therefore, the matter is adjourned to 30th of January 2024. This observation I have given, you go 4:30. You get the bail and we'll come and see, we'll quash it.
Yes.
No case is made out with it.
Yes, yes, Lord. Case made out only apart from 370, you'll also may kindly see, section 370A, capital A. Exploitation of a trafficked person.
How do they know traffic person?
Yes, you know, I am coming to that. Whoever, section subclause 2, whenever knowingly by or having reason to believe that a person has been trafficked, a person has been trafficked by the owner.
How do the customer know? They go pay 2,000 rupees, enjoy and come.
But that is the...
And they'll start identifying where have you come and all identity and passport, everything they'll ask or what?
Minor automatically, we are all human beings. That is the intention of the legislation.
Try to be little practical. They are the people, they are the moneyed people. See the names.
Yes, yes.
Businessman people.
Yes, yes.
Youngsters. They might have gone, paid the money and enjoyed it. And unfortunately, the raid taken place. They are cut. So this is what is the real fact.
Yes.
So we will have to cross those two sections. Why to spoil the life of youngsters? You get the bail.
Yes, madam.
You will get the bail with this observation I made.
31.
31 may please, my lords.
Yes.
My lords, before I place my matter, my lord, there is a defect of my lord, defect number 3. So I may be permitted to remove that.
Ignorable or not ignorable?
Court fee defect, my lord.
Court fee.
My lord.
That is the only revenue the court gets. That
My
also
lord,
will not.
I have furnished, my lord, with the memo. And my lord,
Yes.
with regard to defect number 6, my lord, although I have supplied the copy and which is with my lord, senior my lord, and it has
Let
been
it come in the next week then.
my lord. It was on record, my lord. Inadvertently, my lord, defect number 6 was pointed by the SR.
Anyway, what do you want next week? And
No, my lord. I'm prepared to place the matter, my lord.
Plus, you have the copy?
Yes.
Yes.
My
Tell
lord.
me.
My lord, this is the second round journey of the present petitioner before this honorable court. And my lord, on the first last occasion, my lord, this honorable court order is at running page number 45.
40?
45. Annexure 3.
Yes. Yes.
And on the present ground, my lord, this is out of a matrimonial discord between the parties and which has been settled and snapped by the learned court below, and your lordship may have a glance to the judgment.
No, this the first order is 45. It says that you can raise all these points before
Yes, my
the
lord.
trial court in the appropriate stage.
Yes, my lord.
Yes.
My lord, the only point before this honorable court, my lord, because the matrimonial relationship has been snapped on the account of compromise, my lord. And the compromise, and that was also the finding of the learned court below. If your lordship may permit me to bring my lord's attention to.
What is the offenses? 376.
376 is with regard to 376 and 511, my lord. Attempt. My lord is there. And my lord, if your lordship permits me.
Now, have you raised all these points, whatever points you have before trial court?
No, my lord.
Then?
My lord, I'm before your lordship because that the amicable settlement has been occurred, and my lord, the complainant herself, my lord, she is not interested in pursuing the matter. So, my lord, notice may go, my lord.
Okay. Wife and husband?
Wife and husband.
Then
Wife, husband, and my lord, father-in-law.
Father-in-law. You settled. Divorce is granted.
Divorce is granted if my lord permits me.
Notice to. But you have implemented Srikanti Pradhan.
Yes, my lord.
She is the informant. She
is the informant.
Okay.
She is the complainant, my lord. Not
opposite
informant.
party number 2. Notice.
She is the
Returnable within?
My lord, within 3 words.
She is there in Kandamal.
Yes.
Pulwani. First week, last week.
Last
30, 31, 30.
My lord, may I pray for IA, my lord? May I pray
Yes.
for IA?
What is that IA?
Stay of further proceeding, my lord. Because the NBW has been issued.
They have settled wife and husband unnecessary.
Ajuros.
Stay the trial court.
Highly obliged, highly obliged.
32.
Here, I have challenged the FIR and the subsequent proceeding in a case under section 376 and post quo, my lord. And because of the fact that in the meantime, it has the matter has been subsided between the parties and the petition has merit to the alleged victim.
Notice has to go.
My lord. Or my lord may direct
Opposite party 1 and 2.
They
2 and
did-
3. 2 and 3.
May I suggest, my lord,
Yes.
if the victim has already married, then let them both appear tomorrow and
And
matter will be
tomorrow-
ends.
Because they have
Day after?
Nabrangpur, my lord may keep it on Friday.
Friday. Bring
Yes.
them and we'll finish it up.
It
My
will
lord,
finish.
If my lord, the virtual court is there, if my lord permits, they can also appear from virtual court.
Who will
there.
identify?
The concerned local advocate. And if my friend also assists, they can also appear before the concerned police officer who will bring him to
That's
the
a better
concerned
idea.
Yes. Let them to file the
Yes.
affidavit.
Yeah, but do you have VC facility from the
Yes, madam. Recently-
police station?
No,
Ye-
not police station. They
ନା
will
police
come
station
to-
ଅଛି ଆମର ଅଛି
ଅଛି।
ସୁବିଧା ଅଛି
ତାହେଲେ ଚଳେ।
ଆମର ସୁବିଧା ଅଛି ସବୁବେଳେ
ଆପଣ କହିଦିଅନ୍ତୁ ସେଦିନ appear ହେଇଯିବ ଖାତା
ମୁଁ କହିଦେବି, ମୁଁ କହିଦେବି।
କାଲି କରିଦଉନାହାନ୍ତି କାଲି ପରଦିନ
ନାଇଁ,
ତାହେଲେ ମୁଁ କହିଦେବି
ନବରଙ୍ଗପୁରରେ
କାଲି କହିଦେବି
the cases of Nabrangpur.
ହଉ ଫ୍ରାଇଡେ କରିଦେବା
Yes, Friday.
Friday
ଆଜ୍ଞା,
police station ରେ appear ହେଇଯାନ୍ତୁ
and at least they will produce the victim
Yes,
with
yes.
the accused.
they will have to go there police
Yes,
station
yes.
ସେଇଠୁ appear ହେଇଯିବ କହିଦେବେ ସରିଲା
ସେମାନେ
ଠିକ ଅଛି।
ଗଲା ମାନେ ମୁଁ କହିଦେବି ତାଙ୍କୁ ସେ
ଠିକ
କରିଦେବେ
ଅଛି।
ଠିକ ଅଛି
ଖାଲି no course of action till Friday.
ଆଉ କାହିଁକି ସେ ତ
Friday
ରହିଯିବ
ତ-
ସେ ତ ରହିଯିବ ଗୋଟେ
Husband has
ଡେଟ୍ ରେ
to
ସରିବ ଆଉ
accompany.
କଣ ଅଛି
Huh?
Husband has to accompany. Husband has to accompany, my lord. Only till Friday. Till Friday. I'm not paying for more.
ମୁଁ କହିଦେବି ଆରେଷ୍ଟ କରିବେନି
Verbal କଥା କଲା police କଥା ଜାଣି. My friend also knows better.
no, then I'll pass an order
Madam.
but so that you
How
are
that?
protected
Only till Friday, no course of action.
no what is the what is the allegation 370 who
Aye.
is 2 and 3
ନାଇଁ 373 କରୁଛନ୍ତି ଏବଂ କହୁଛନ୍ତି ପୋସ୍କୋ ଆକ୍ଟ ବି ଲଗେଇଛନ୍ତି.
Can I have the
But
note?
I have the document which shows that she was 17 years 10 months on the day of occurrence. 17 years 10 months. Now she has crossed 18 years. And after that, my lord, because of the fact that they were having relationship.
no, the POXO is there I can't even cross
No, my lord may take note of this aspect. Because of the fact that they are married to each other, now living a happy conjugal life, it's a consideration.
ସେଟା କେତେ ବର୍ଷ ଝିଅ କଣ
So, 17, I'll file through a say affidavit and I have the document. 17 years, 10 months on the day of occurrence. And now 18 years and more.
now maybe
Minor,
but
minor.
the date of occurrence she was a minor
17 years, 10 months.
minor
Admittedly, 17 years.
then
10 months.
POXO is involved
Yes.
then,
Four-
then
four of the-
then
but one thing-
technically there is an offense which is not to be quashed.
No, my humble submission, my lord, kindly appreciate. Because if my lord will interfere in this particular matter, because what is the substantial justice will be solved if my lord will interfere.
Show me
Because
some judgment
Yes.
where show me some judgment.
Yes, on Friday also. My lord will keep it on Friday also.
Friday go tomorrow.
tomorrow
You want to stay then tomorrow.
Solid.
Tomorrow. You come with the judgment, then we will stay and
My lord, and keep it on Friday.
that will help.
My lord.
In many cases, these kind of see what happens is if the what is the age of this
No,
your
the-
client is
although
21.
at the relevant time, the BS Joshi versus
Many a time the accused is also minor, the victim is also minor.
No, my lord,
They
BS
marry because
Fast-
elopement case.
Past judgment of the apex court, matrimonial offences, the honorable court should incline to pass order at any stage, at the stage of investigation, charge sheet or subject, because the paramount considers the welfare of the parties. If it's a matrimonial offence, it's a case of that nature. And here, the parties have already married to
Now
to
who
each
is
other.
that Sajini is 18 years.
Mother-in-law.
And no, she co-settled. Both of them are 18 years.
18 years on the day of
Sajani Batra
on
is
the
18 years. Who
on
is
the-
she?
Sarojini Bhatt, sorry, 38 years. I'm sorry. She is the mother-in-law. Mother-in-law. Man, they're doing the mother of the victim. Mother of
Mother of
opposite partner of 3.
mother of your
Opposite
client.
partner no. Opposite partner 3 is the girl.
Mother-in-law of your client.
Yes. Yes.
And Dhani Batra is
Is the girl, victim.
Dhanai Batra is the
Girl, victim.
And now you married.
Well,
ଏ ଦି ଜଣ ଅଛନ୍ତି
ନାଇଁ ଜଣେ କି
ନାଇଁ ସେ ଏଇଟା
ଧନାନୀ ଭାତ୍ରା
ଏଜ୍
ଧନାନୀ
18
ଭାତ୍ରା
ଲେଖା
ହଉଛି
ହେଇଛି
victim.
mother-in-law 38 that is.
ଭିକ୍ଟିମ ଆଉ ଗୋଟେ ସଞ୍ଜୟ ଭାତ୍ରା
ସଞ୍ଜୟ କି
ଏଠି ଲେଖା ହେଇଛି ସଜନୀ
ସଜନୀ ହଉଛି ପୁରା
Sajani is the
mother-in-law.
mother-in-law means
of the petitioner.
mother of the
ତାର ଏଜ ବି 18 years ଲେଖା
that
ହେଇଛି
is what I was wondering. You satisfy them
Yes,
tomorrow.
yes, ma'am. Yes, ma'am.
Get some judgment, we can help these people. In the tribal area, this is the whole problem. They don't see age and all, they elope with the boy.
Age is not a bar, my lord knows for.
There is no bar, but the act, what to do? In
And
tribal
my lord
area,
also
this is
keep
the
a-
biggest problem.
My lord, my humble submission, when the party has not married, my lord may take its stringent view. But when the parties has married to each other, and they
90% of marriages there in those areas, the boys and girls are below
Yes.
18 years. What to do?
That is
If
it.
something happens, they go and file an FIR, the boy gone, life gone. That's the whole difficulty.
And now in view of this changing my lord, scenario, the age has also been extended to 18
Then
instead of
it's
16.
more dangerous. They don't take into consideration the tribal culture. That's the whole difficulty.
This fact was realized by the legislators when they framed the old act. But with development, we are becoming regressive.
That's very unfair for the tribals, you know. Tribal, they marry at 11, 13 years.
General also.
You please assist so that we can, in these kind of matters, at least we will try and help other people. Get tomorrow, day after tomorrow.
Day after tomorrow.
So that you can get some
Well,
time and
definitely.
get some judgment. And in the light of the tribal culture also you get something. If you can get some literature. We can invoke that also, we'll try to find out some way out. 33.
Please, my lord. My lord, here, my prayer is sought for a direction to the secretary to accord permission under section 197. My representation is there. My lord, by annexure 2. Let the secretary take a decision on.
You are the accused.
Yes. Now, here is not accused. I am the landlord. My land has been taken away fraudulently. So I sought for to move to file a criminal case against the persons. I sought for the sanction that is under section 197 by the authority. So my representation there, let the authority to take a decision.
And to my knowledge, my lord, this application earlier was filed before this honorable court. And no certificate has been given, subject to correction of my learned senior.
Have you filed any petition?
I have no idea. But only
Verify.
Inaction policy was.
Inaction
Moreover,
is different.
Inaction policy, same point was raised before the inaction.
Inaction of policy is different. To got a sanction that is according to section 197 to proceed against the government officials, that is different.
And that
see, sanctioning authority has its own discretion.
Yes,
yes.
How can there be a direction?
Yes, exactly.
The only direction to dispose of my representation. I don't compel that my
that jurisdiction the court doesn't have.
Yes.
I don't compel my lord that to give any sorts of direction, only to dispose of my representation. Either in the positive or negative. Where what the authority may be.
But what is the procedure?
Tantamounting to interfering in their jurisdiction.
Sir, only to dispose of my representation, nothing more. Only what to dispose of my representation by annexure 2.
Exactly the same point has been raised by my senior.
482 jurisdictions are to be used like this.
Sir.
Try to appreciate. 482.
Why
start interfering?
Sir, 482.
Give sanction.
Sir,
give sanction. All these things are to be done by them.
Very wider jurisdiction. Honorable Apex 482 jurisdiction is very wider jurisdiction. As good as the REIT jurisdiction.
Whether 197 is applicable or not, that is the concerned authority.
You see, wider jurisdiction, no problem.
Yes.
And it can't be an irresponsible jurisdiction.
No. That will be decided by the competent authority.
And who will call for the 197 sanction?
If he gives or if he doesn't give, that is
only I withdraw my petition, grant a liberty to approach this opposition.
First of all, you tell me what petition you have already filed.
Then he says that
exactly.
inaction of policy.
Exactly same point.
Inaction of police is including the sanction.
No, not sanction.
Yes, same point. I was there in Honorable Justice.
Again, prima facie
I'm putting it tomorrow.
Get
that petition. I'll put it tomorrow.
Tomorrow,
come with that petition. Let us see.
Sir, only that is the inaction of police means non-registration of FIR. That everybody knows the inaction means non-registration of FIR. No sanction is required for that is in CRLMP.
Let us see.
All right.
Let us see.
Not day after tomorrow.
Day after tomorrow. Let us see why you are necessary.
Yes.
About the petition,
only to dispose of the petition, I want to withdraw this petition, liberty may granted to ventilate my grievance before the
ଆପଣ
authority.
ସେଇ ଲାଷ୍ଟ ଅର୍ଡର ଟା ନେଇ ଆସନ୍ତୁ ସେଇ ପିଟିସନ ର ଦେଖିଲେ
ଯଦି ସେ ଜାଣିଛନ୍ତି ସେ କହିଦଉନାହାନ୍ତି, ସେ ଜାଣିଛନ୍ତି ସିଏ ସିଏ କହିଦିଅନ୍ତୁ କଣ
ଆପଣ କୁହନ୍ତୁ ଯେ ଆପଣ you are the petitioner, counsel for the petitioner.
ନାଇଁ ବୋଲି
You file an affidavit, I will show.
ଆପଣ କହୁଛନ୍ତି
କାଲି I am putting it tomorrow or day after, bring it and finish it up.
No, no, if my learned friend is also knowing the number, he can also disclose what is the number about.
See, many a time
Na kariye, na kariye.
ଆପଣ ଯଦି ପାରିବେନି, even if accepting, my lord, even if accepting, this is not the forum to
that is a different story. We will see that
My
day
lord.
what can be done. And he wants to withdraw it.
With a liberty to approach the authority.
That liberty is always there.
Yes, that objection can be disposed of. Only to save the precious time of the my lord.
197 টা কোড কেমিতি what is the procedure?
Court doesn't have 482
procedure?
court can.
197 কথা পড়িনি because my reputation disposal.
But সেটা হেলানি কি?
কোন হেলানি?
See, learned counsel for the petitioners seeks to withdraw this petition to avail the remedy available to him under law.
As per representation.
Available to you under law.
Law
Whatever
only
available, do
representation.
it.
Sir,
I don't know.
only one line. As per representation.
The CRLMC so and so dismiss as withdrawn.
Yes.
Dismiss or dismissality অসুবিধা নেই।
Dispose of. Dismiss stands withdrawn.
Not dismiss.
Dismiss word itself is maybe stands withdrawn.
Sir, much obliged, sir. Much obliged.
And do whatever is permissible under law.
Sir. 34.
May please your lordship. My lord, the matter dispute between the parties, a matrimonial dispute,
Yeah.
and already
Settled.
settled.
Uh,
With the opposite party of file
Vishnupriya Maharana.
already.
Bring her.
Yes.
She is there.
Then advocate is appear and he had filed the serious to that. Oath commission.
No, you have the vocalat now.
They already appear, my lord, that the name already reflected.
Where is that? Compromise petition is there.
Yes, brother. Yes, Natia. Yes,
You
Natia.
sign, huh?
Yes, Natia, Manoj Kumar Swami.
Vishnupriya Sahu. Priya Sahu. And you have written
ଗୋଟେ copy
Vishnupriya Mahapatra. How will I?
ଆମକୁ ଗୋଟେ copy-
Sahu. Maharana Sahu. Okay. After marriage Sahu. ठीक है.
affidavit ଦିଅନ୍ତୁ କାଲି ତାଙ୍କୁ ଡାକି ଦିଅନ୍ତୁ ଦି ଜଣ both party will appear before your
Both the
lordship.
party appear tomorrow. Second item.
Dispose of.
Item number 2 tomorrow.
Yes.
They have already they have
No. Yeah.
request.
Compromise ହେଇଛି ଦି ଜଣ ଆସି ପହଞ୍ଚିବେ।
Don't take that chance. It is good for you.
No,
Tomorrow they'll start blaming the lawyers also.
No pledge, man.
Impersonation, somebody
ସେତେବେଳେ କଣ
came,
ହବ ତ
appeared, all
ଶୁଣା
these
ଅଛି।
things. Why to
ଶୁଣା ଅଛି।
take risks? Bring them, we'll do it. Tomorrow?
Yes. ଆପଣଙ୍କର day after tomorrow.
Day after tomorrow.
Day after tomorrow.
First item.
First of
Item 1. So that they'll come and 10th.
ये ताले मैंने मंडे को मंडे से then
Monday.
Monday
Monday on 8th, first item.
oblige
35.
The stamp report has shown a defect. They have removed the defect.
Yes.
Please, your lordship. Petitioners here assail the order at annexure 1, my lords. Page 16 of the brief.
1.
That's an order taking cognizance. Page 18, my lords.
Yes.
Right.
13/4/23. The
Yes.
order. Office note.
Is the order
ID,
dated?
is
Yes.
Same. Then council PP, PMT.
At least that on the basis of FI number such and such.
Section 3, 4.
My lords.
Yes.
Now, my lords, so far as these petitioners are concerned, petitioner number 1, my lords, is an ex-MLA.
Anam Naik.
I.
And
petition number 2 is a spouse, petition number 3 is a son of his.
no, you have only 2 petitioners. Three petitions, right. Sukanti Naik and Praveen Kumar.
Right.
And one is the XMLA wife and done. Okay.
Now your lordship may look at the FIR of the vigilance.
What
which
is the predicating offense?
13 millards.
13.
Yes.
Okay.
If your lordship will look at page number 55 millards. Annexure 3. That is the FIR in the predicate of.
Predicating offenses 13 to
13-2 read with 13-1B of the
1B.
PC.
Yes.
This FIR was registered on 22-1-2020.
20-1-2020. Yes.
And investigation is going on. It is not yet complete. Now, in this FIR, millards, the check period which the vigilance took, millards, that has been stated by them
From
at page 58.
58 is from 185 to
17-1-2020.
17-20.
Now, millards, during this period, millards, the petitioner number 1 was in government service in various departments. During the
PMLA, just give the PMLA. Which is the date when the predicating offense was?
Yes.
That's the date you will see if it is falling under that or not. Simple.
Right. That's what I'm going to say.
So PMLA. Predicating offense.
PMLA Act.
When was it notified? He is ready with all weapons.
I'm not with the notification also. Now your lordship saw the check period with the vigilance.
Yes, that is
1-1-85 till
85 to
17-1-2020.
120.
2020.
Okay.
Now during this entire check period, millards, from 31-3-2004 up to May 2014, the petitioner number 1 was not in public service. 31-3-2004.
31-3-2004 to
5 May 2014.
14.
He was not holding any public office whatsoever.
Okay.
Then, millards, again from May 2019 till the date of search, millards, he was also not holding any public office.
19 to 7.
But the vigilance took it as the check period. Now, having taken it as check period, millards, they outlined the assets and other things, millards, and lost the effect. Where investigation as on date is continuing. Till date, they have not filed any charge. Now, assailing this FIR, millards, I had moved your lordships, millards, in a 482 application.
That is Annexure 4.
That is Annexure 4, millards. Now, if your lordship will look at Annexure 4, that's at page 68, millards. My lords may look at paragraph
3.
Perused copy of the FIR at Annexure 1. In fact, later to the lodging of the FIR, Vigilance PS case 3 dated 22nd January 2020 was registered under 13.2 read with 13.1B of the Prevention of Corruption Act 88. In that connection, investigation was commenced, which is still underway. That paragraph 4, your lordship may see. Learned counsel for petitioner submits that some of the assets acquired by the petitioner while he was not in service have also been included by the Vigilance Department and are the subject of investigation at present, which should not have been, although he was briefly out of government service and was in service for certain periods. In response, Mr. So-and-so, learned counsel for the Vigilance, admits that petitioner was not in service for some periods by referring to the details of assets mentioned in the FIR itself and the dates of purchases. In view of the above, court is of the view that assets acquired by petitioner during such periods while he was not in service should not be included for the purpose of investigation
And for that, he cannot be proceeded with, which has also been acknowledged by learned counsel for the vigilance department. Vigilance is directed to exclude all such assets that have been acquired by petitioner during periods while he was not in service and proceed with investigation with other subjects. This was the direction passed to the vigilance.
Right.
Now, whether the vigilance has done it or not, I am not in a position to say, because they are yet to file charge. Now, so far as the PMLA is concerned, your lordship knows that the PMLA swings into action when predicate offences are committed, when FIR is given, supplied to them. Because without an investigation by the persons conducting it into the predicate offences, they cannot register or take. But what they do is, without waiting for the results of the investigation, they initiate proceedings, my lords, which they have now done by filing a complaint. So in this complaint, which is filed here at Annexure 2, my lords, they have included whatever is there in the FIR. They have also not excluded properties acquired by me and by us and assets created by us during the period when Hon'Ble Naik was not in public service or he was not a public servant. The second thing, my lords, is whether an offense, predicate offense has been committed or not is yet to be established by the vigilance authorities submitting a charge sheet. Now, without that having come into being, my lords, the PMLA authorities have said that yes, a predicate offense has been committed by me and I am liable for having laundered money. And hence, they filed the FIR without even waiting for the results of the investigation into the vigilance.
Hold your hands till the charge sheet is filed.
My lord.
Hold your hands till the charge.
No, my lord. Kindly, your lordship, bear me 1 minute. My lord, here, once FIR is registered under the schedule offense, ED gets power to investigate and file complaint.
But no, the only part is this order.
No,
says
no, my lord.
exclude that part.
This order says regarding exclude that part where now ED is investigating and filed a complaint. He is to satisfy from where he got that property.
That part of the property is to be excluded
No, my lord,
from the purview of investigation.
No, my lord, that part of the property is excluded for the purpose of investigation by vigilance department because he was not a public servant during that period. But from where he acquired those property, that he is to satisfy. It may be from the proceed. It is from the proceeds of crime. So on the basis of that, a complaint has been filed. And Honorable Apex Court, your lordship knows in Vijay Madan Lal case has said, ED gets power the moment FIR is registered. Your lordship kindly see.
That's right. That is there. That is there.
So we have filed the complaint. Court has taken. This is not the stage to quash the cognizance, my lord. FIR, my lord, I could have understood if FIR could have been quashed. Vigilance FIR could have been quashed. I have no case. But vigilance FIR till that stands.
Now the limited question is, if there is a court order which you have accepted.
We have not accepted, my lord. It's a schedule. Offense under the schedule offense under the PMLA are two separate and distinct offenses.
My question is something.
Yes, my lord.
What I'm saying is, if there is a judicial order where you have not attained finality, you have not challenged that.
No, that is not against me, my lord.
Exclude this part of.
My lord, that is against by the vigilance department. That is not by the ED.
That's right. My question I have not completed.
So I cannot challenge that order. No. I cannot challenge that order.
You are a state for me. And
no, my lord. I am state, but there are two different.
There is a legal issue now.
Separate agencies, my lord.
No, the legal issue.
Yes, my lord.
What I am thinking is,
yes,
I may be wrong.
Yes, my lord.
If a judicial order is there to exclude some part of the property from the purview of investigation
by the vigilance department,
whatever.
Yes, my lord.
Because you derive the power from the FIR up to that
yes,
FIR. Because that predicating offense goes, then you are gone.
Yes, my lord.
You are nowhere into.
Yes, my lord.
If the predicating offense excludes certain property,
yes,
can you include that in PMLA?
Predicate of suppose in a predicate offense there is no property. Only FIR has been filed. We investigated and found that he has
That's the difference.
It's
That's
like
a
that,
different scenario altogether.
It's like that, my lord. He was a public servant. He acquired certain property. FIR is pending. For a certain period, he was not public servant. This court directed to the vigilance department to exclude that property. Now we are investigating that matter, and we found that those property has been acquired out of the proceeds of crime. When he was in the service, he acquired the property from the proceeds of crime. And now your lordship sees section 24.
Now, if there is a,
there are two
there is a, no,
I give an example.
if a simple sitter FIR is there, predicating offense FIR is there, you have all the right to take away all property during that.
Otherwise,
If
also I have
a
to
defined,
investigate. I cannot confine my investigation to that FIR.
Can you travel beyond
Yes, Lord.
beyond the
FIR.
check period, beyond the check period?
Yes, my lord. I can investigate.
Show me the judgment, then you can travel beyond the check period.
I can
if you can travel beyond the check period.
Not check period, my lord. I can investigate whether the property is acquired in proceeds of crime or not. It's immaterial when he acquired.
No, just
check period is immaterial.
Just assist me this. Being a PMLA.
My lord, I give example. Suppose I committed a predicate offense. I collected 1 crore rupees to murder somebody. I kept this money to the wife.
And thereafter you investigate.
So I can investigate everything. It's not that I cannot go.
No, that is not troubling me. Troubling me is something.
I
suppose today I have been apprehended, a predicating offense is registered. I have accumulated money from that offense. After 2 years, I can also invest it. So then you have a power to investigate the entire part, no problem. But today the situation here is, there is a court order to say that they exclude this part.
Court order to the vigilance department, my lord. It's not to me that I cannot.
Is it not binding that you say that any order, it is in RAM?
No, my lord, that is not, because it is here. I have to investigate that entire.
You do it excluding this part.
I cannot, my lord. I just say period. Suppose to move 10 ବର୍ଷ ପୂର୍ବରୁ ଗୋଟେ ନେଇ ଚୋରି କରିକି ରଖିଛି ପଇସା.
Who stopped you to challenge this order? Who stopped you to challenge this order?
I am not party there in
then
that order.
Even if something is hurting, you can go.
No, it's not hurting me. It is for the vigilance department. My hands.
Now it will start hurting you.
My hands are not tied. I cannot. It's not that I cannot investigate. I can investigate all. Suppose.
You can investigate all. There is no doubt about it.
Lord. So,
but once the court says that don't investigation this part,
to the vigilance
you have to hold your hand.
To the vigilance department. Court has not said.
You derive the power out of that only.
No. My power is only the registration of FIR. I get the power to investigate everything. Your lordship, kindly see this judgment.
My lords, can I just interrupt for 1 minute?
Yes.
My learned friend said one thing, I am quoting him, that I committed a predicate offense. My lords, when do I commit a predicate offense? When a charge sheet is filed or during investigation? Then, my lords, my learned friend says that he will not exclude me. My submission is this. He has the right to take up investigation, but he doesn't have the right to conclude the investigation until and unless the predicate investigation into the predicate.
No, I will put it further. What my way of looking into this order is, the court says that insofar as this particular period where you are not the public servant, you have not committed predicating offense. If you have not committed predicating offense, then how you got the authority to enter into that area?
Go down to what your lordship is.
How can you enter into that area?
Go down to what your lordship.
Forget about the property part.
My lord, I am not on that.
This order says that he has not committed. He has not committed predicating offense insofar as this particular period is
agreed, my lord.
When you are not holding the office of profit.
That part has been, FIR has been registered for 88 to some period.
Yes.
I investigated. Found he has these property. I have no connection with this part. Found these property he has acquired, which are according to me, which are proceeds of crime. So I can investigate and file charge sheet.
No. You can investigate.
In the face of this order, you can't, according to me.
No,
in the face of this order,
lordship, kindly see this judgment. The Vijay Madan Lal judgment. Your Lordship kindly see.
Why ED cases have bigger judgments only to confuse?
No, my lord, this is, my lords of Apex Court has delivered this judgment, my lord.
Yes, tell me, which paragraph?
Your Lordship kindly see para 288, page 87.
288. Yes.
Para 280, page 87.
280 or 88?
280.
280. Okay.
0.
Yes.
We may also note that argument that removing the necessity of projection from the definition will render the predicate offense and money laundering indistinguishable. This, in our view, is ill-founded and fallacious. This plea cannot hold water for simple reason that the civil offense in 2002 Act, as it stands, are independent criminal acts. It is only when money is generated as a result of such acts that the 2002 Act steps in as soon as proceeds of crime are involved in any process or activity. Dealing with such proceeds of crime can be in any way, in any form, being process or activity. Thus, even assisting in the process or activity is a part of the crime of money laundering. We must keep in mind that for being liable to suffer legal consequences of one's action of indulging in the process or activity is sufficient, and not only upon projection of the ill-gotten money as untainted money. Many members of a crime syndicate could then simply keep the money with them for years to come. The hands of the law in such a situation cannot be bound and stopped from proceeding against such persons if information of such illegitimate money is revealed, even from an unknown source. Suppose, my lord, he acquired the properties during when he was the public servant. He purchased those property after he resigned from the service and became MLA. Can I not investigate?
Who stops? Who says no? You can do that.
That is, I investigated, found, and I have filed a complaint. And what my learned senior is saying, my investigation is not complete, my lord. My investigation is open. Investigation is going on. It's not that I closed the investigation.
How can an investigation go on after filing a complaint?
What is troubling is if a coordinate bench of this court says that don't account for the assets or like whatever he has acquired in a particular time when he was not holding the office of profit. Can the other agency for the state
yes, my lord,
can enter into and do it?
It's a, my lord, because it's a separate and independent offense. Jodi agya sei year continuation ei thanta tale mu kari par na thandi. It's a separate and independent offense.
Can you show me any judgment where it suggests that beyond the check period also you can?
I'll find out.
Because if you can go beyond the check period, then you can.
Not only check period, I can investigate everything, my lord.
Let him file a response, my lord. Let
you file response. It's a legal issue. Let us settle it.
Yes, my lord. I'll file.
Good issue.
Because what has happened in some cases today, actually, I received copy yesterday night, so I could not even get all. In some cases, my lord, what has happened? FIR registered in 2020, but he acquired property in suppose 70.
That also you can do it.
So they said, no, my FIR was schedule offense I committed in 2020.
You can do it.
Cannot investigate.
You can do it.
It's like that, my lord.
It's not like that.
It's like
here
that.
There is a specific order. Don't touch that property.
Specific order to the vigilance department, not to me. My lord, I have
to the state.
Schedule. I have
for him. All the investigation.
My lord, I have no connection with the schedule offense, my lord. Your lordship, kindly see the next para of that judgment.
Yes.
And
And next question is whether the offense under section 3 is a standalone offense.
Yes.
Yeah, this proposition is undoubtedly correct. I am not saying that.
So, my lord, I can investigate
but the factual position is different in this case.
My lord, factual position is I have no connection with the schedule offense. Suppose I could have investigated schedule offense, then I cannot do.
No, you can't say that you don't have a connection with it.
I have
You derive your power from the schedule offense being committed.
No, my lord, offense under the schedule offense under the PMLA Act are separate and independent offense.
There is no doubt
Then,
about
my
it. There is no doubt about
When
it.
it's a separate and independent offense, I have to independently investigate. I cannot be dependent.
Suppose
on that.
expand this order
Yes,
for
ma'am.
the coordinate bench.
Yes, ma'am.
If the coordinate bench would have said, no, this is not the check period, you can't touch this property in the check period, where from you get the jurisdiction?
On the basis of FIR, I can investigate all how many property is required. Suppose ये order नथांता से period. मु पूरा तार कितने property से आने के I could have investigated.
But see, another scenario, just see, if the vigilance department files a charge sheet saying that no case is made out,
No,
because excluding that part, no case is made out, where from you get?
Vigilance files a charge sheet, but when on my
No,
investigation,
vigilance files a final report in his favor, then what happens?
my lord, if vigilance files a final report in his favor, passing entire that there is no case,
So
then I have no.
Then you are hold your hands till the business file
I have
charge sheet.
already filed the complaint. Court has taken.
So that don't proceed further.
No,
Who knows that? See, I'll tell you, if that major period goes,
Not major
it may
period,
so happen. It
not-
may so happen that they'll end up filing
It's
a
not major
closure
period.
report.
It's not a major period. From 88 to 2020, only 2 or 3 years. Major period.
We don't know in that period how much is got, whether it is disproportionate or not. All these things end up in a final report.
I guess-
Then your jurisdiction goes.
No, ma'am. Honorable Apex Court said once FIR registered, I get power to investigate and file a complaint.
that? Nobody says no to it.
Milord,
You have a power.
But accordingly, Milord, I have investigated, filed a complaint. Now questioning whether at this stage this proceeding can be quashed.
Why not? You file a response.
Have you implemented vigilance department here?
No, Milord.
You implemented.
Vigilance is no way concerned with them.
No, I just want to know when they are going to file charge sheet. They may file a final report also.
They may take another 50 years for all I know.
So it's but vigilance.
They are taking advantage out of it.
My submission is this.
Connection with
Milord, my submission is this.
Suppose, Milord.
What my learned friend is saying is something he is speaking out of the hat. He admits, Milords, that he will take up an investigation when a predicate offense is committed and an FIR is registered. The Supreme Court says so. Yes, I agree. Supreme Court doesn't say what my learned friend is saying, that once upon an FIR is registered, you can take up investigation and conclude it. Because the conclusion is dependent upon
Contingent
whether
upon
Yes,
that.
Exactly, my lord.
Your
And
lordship.
that is what their lordships have said in Vijay Mohan Lal also. Specifically, their lordships may say,
It is contingent.
while interpreting section 3 of the 2002 Act regarding the offense of money laundering, it can proceed only if it is established that the person has directly or indirectly derived or obtained proceeds of crime as a result of criminal activity relating to or relatable to a scheduled offense. This is what the Apex Court also says.
Milord,
I am not saying that the Apex Court is wrong.
when Apex Court has gone saying, suppose in schedule offense, he is discharged.
Yes.
Apex Court said, then the court is to give a finding that the property acquired is not proceeds of crime.
Then
In
again,
that schedule offense, the court is to also give
that's
a finding.
what I am saying.
Exactly.
So it is your investigation is relatable to a property which has been excluded by a judicial order. So therefore you can't touch that property.
No, I can investigate all. If I
By way of a judicial order, it is excluded. X property is excluded.
Milord, those property.
Can you bring that X property into the money laundering
Because I
part?
have to take instance, I think there is a provisional attachment order has been passed. Against that, my friend has filed a CRLMP is also pending.
That should be stayed.
No, and that order has been confirmed by the adjudicating authority. So he is to go in appeal for that.
Appeal lies there.
For that, he is to go in appeal. So
Then indirectly you are saying that you have to file a reply.
no, I have to file a reply. I file a reply.
It's a question, pure question of law. Prima facie view is if there is a judicial order to exclude some property, no
And
investigating
satisfy
agency
Milord.
can touch it.
No. Suppose I can investigate all below.
You investigate.
Reply টা file
I'll file reply. I'll reply not.
ଅଯଥା କାହିଁ ସମୟ ନଷ୍ଟ କରୁଛ ଆପଣଙ୍କର ଆମର ସମସ୍ତେ
Yes. Issue notice to the
I filed appearance memo.
appearance. Mr. Agarwal enters appearance on behalf of opposite party number, opposite party, sole opposite party, and seeks time to file reply. 2 weeks. 2 weeks time is granted to file.
Grant me some more time. I will not hear for a week.
And then next
Your lordship keep it in first week February. Last week January
But thereafter what will happen? What Mr. Pandya is looking
nothing
at you.
will happen, my lord. Now it is fixed for appearance. Nothing will happen.
Your lordship will only say that the court will not insist on my appearance.
No, my lord. He filed an anticipated bail, rejected. Then
Is this ସେଥିରେ କଣ ଯାଉଛି?
No, now it is fixed for appearance. No, nothing is going to happen.
The land council for the petitioner seeks a direction that he should be exempted from appearing before the
And 205 also
PMLA
filed
court.
rejected.
PMLA court. You can appear through VC. You can appear. The liberty is granted to the petitioner to appear to video conferencing before the PMLA court, as and when required. Video conferencing.
Here, my lord, anticipated bail rejected. He filed 205 application, that is also rejected. My lord, all orders.
सब सुप्रीम कोर्ट जाए VC हेलानी
VC हो more सेटा more से ताजर की असुविधा नहीं. VC रो but he must appear.
As and when is required.
As and when required.
Required, they will appear to VC.
My instruction, court has directed him to appear. Date of
I am also saying he will
Yes,
appear
yes.
through VC as and when required. Substantial proceeding तो हबार नहीं. किसी हबार नहीं.
अबिका से खाली appear कले हमें RUD हरिका दबु से फिर बहुत.
But I will only request you can seek some instruction from vigilance department also. You are the state.
No,
You are
no.
prosecuting him.
I cannot.
You are the state.
My lord, vigilance.
You can do anything.
Vigilance will not cooperate us. That's the problem, because we are central agency, they are state, it's their district, they are not cooperating with us.
Otherwise, next time I will implead, so much I will implead.
That
vigilance.
up to, they are
Because
not,
see, because of these two agency, he is suffering.
They should go by tandem.
You have to go by tandem.
I will satisfy your lordship that once FIR registered, whether that property was there or not, I can investigate on.
You, there is no quarrel on that.
Yes, ma'am.
Who says
Regarding
you can do it? Of
This
of
order
course you
also-
can do it.
This order also I will satisfy, ma'am.
But if the judicial order that is that don't touch this, you don't touch it.
Vigilance department, that order is not binding.
No,
on
no,
me.
it is on
I
RAM.
was not
It
party
is,
there.
it is
I was
against,
not heard there.
it is against state. If he is
No,
not heard, then
against state, but I was not party, I was not heard there.
who stops you to challenge it?
Milord,
Today you can do it.
today it came to my notice, that such an order has been
And next time you come and get a stay.
Today this order, that's a difference. Today it came to my notice, only yesterday sir me copy. So today it came to my notice, such an order is there.
And there is a provision to leave to challenge.
There is probably.
You can seek leave to challenge.
No, no, my lord, even suppose ତାଙ୍କର ସେ property FIR ହେଇନଥାନ୍ତା, ଆମେ ପାଇଲୁ ଗୋଟେ ଲୋକ proceeds of crime, we can write the jurisdictional police to register the FIR.
Everything is all right. ED has
You
ample
can
power.
write, But until the jurisdictional police registers the FIR.
FIR has, here not FIR has been registered. Only distinction is this court has passed an order to exclude certain part of the property.
There are many
But
more things.
once
I
a
will also
person is found, your lordship kindly see.
But it is
section
not
3
so easy now.
Section 3 of your lordship kindly see of that act.
Whatever you are saying, I am completely agreeing with you.
Section 3.
But
my
what
lord's
the
kindly-
only question is, if there are X, Y, Z property, a judicial order is there, don't touch X property.
Judicial order.
Can
I will satisfy.
can you
my-
touch that?
I have no jurisdiction to interfere with the investigation with the vigilance department. My investigation is separate and independent. I found that this property has been acquired by proceeds of crime. I can proceed, my lord.
See,
I'll satisfy, my lord.
okay, but
I'll
for an accused, whether you are ED or you vigilance, doesn't matter.
No,
For an
no.
accused, you are the state.
No, my lord, matters.
You are prosecuting.
It matters, my lord.
You can't say that I can't run tandem with X, Y, Z, then he can't separate.
ताहले vigilance trial, ये trial एकटा संगे रही था.
No, Simitu.
ताहले तो एकटा संगे रही था. If I have to run behind it, that's why a separate power has been
No,
given.
you have to step into the shoes of an accused. For an accused, who is prosecuting? State is prosecuting. State may be center or state.
That's true, my lord. That's true.
For him,
But my power is different. Vigilance power is different.
चलो तो फाइल करो.
हाँ, फाइल.
It's a legal issue.
File.
So I show for matter 22.
Oh, immediately after lunch.
After launch, I will have.
Oh, 22 adjourned for next week.
No, tomorrow, my lord.
Tomorrow.
Urgency.
Tomorrow, no problem. Thank you, sir. What do you want? No. You want listing? You give it. We will follow a system, and your matter will come up. Don't worry. But it's all right. Now all the matters will come. Don't worry. You will see that every matter. System में जो था ठीक पता है आगे पीछे करिए. Yes.
Item 3.
Yes.
Please, Your Lordship.
Yes.
In this case, the petitioner challenged the impugned order under Annex 2, my lord. The rejection, he filed a petition for a discharge of the charges, my lord. Now that has been rejected under Annex 2, ignoring all the valid points under Annex 1. Where my sole contention in this instant case, the petitioner during his incumbency in service as SCO under the administrative control of the DOPO, under the instruction and authorization, he has executed some works, but the concerned DOPO issued TT permit as per the statement of PW4 Miller. His petitioner has no nexus to the allegation, and his involvement does not arise in this instant case. It is the case registered in the year 2002 Miller. So I would like to draw your lordship's attention. Please have a glance. Annex 1, page 9. The factual matrix of the case and some valid points are there. Ignoring all these points, learned trial court rejected the petition under Annex 2 Miller. Which glance Annex 1, page 9. It is very clear from the apparent charge sheet that some people of Bhatra caste of village Konga, PS Jhariga, district Navranpur, are having their respective lands with record of rights, and they have raised Bijo and Sala trees on their lands. That on C-9699, they have submitted the respective application under form number 3 before the DO for Navranpur for obtaining permission for cutting and selling their trees. As per the provisions of the Forest Act, the DOPO, namely Jagannath Sahu, perused those applications and passed an order for joint verification over the concerned land and trees, along with the Tahsildar Amarpur and field staff of Forest Department. Accordingly, the Tahsildar, by the help of concerned revenue inspector, Amin and Forest staff, inquired about the land and standing trees at the field and submitted the report to the DOPO under the Tahsil case records bearing RMC number 4 of 99. After all these official procedure, the DOPO Navranpur, as the competent authority, passed an order
to cut 30 number of bijou trees and 67 numbers of sallow trees, and for converting them to timbers for transportation. So my sole contention, the second paragraph, it is submitted that the learned, the relevant period, the above named accused was serving as a SCO, that is Additional Chief Conservator of Forest, under the DOPO, Nabarangpur, and as per the order of his higher authority and written instruction issued him by memo number 8700 dated 27/12/99, he was duty bound to issue TT permit for the fallen trees timbers.
Who all are the accused?
My lord.
Who all are the accused?
Accused, my lord, the
DFO?
Divisional Forest Officer and SCO.
And
SCO, my lord.
Tahsildar?
Tahsildar, they have not added as a party.
And
Accused, my lord.
RI and all?
Not.
And the forest staff who has gone for inspection?
My lord, on competent authority, the DOPO.
Maybe.
DOPO
acts on the basis of the report
just
given
I'm
by.
drawing to your lordship's attention. On 27/12/99, the concerned DOPO issued a letter. My client, he was the duty bound to issue TT, though he is the subordinate. TT, that is timber transit permit for the fallen trees. And at that time, my lord, the trees are fallen. However, the above named accused verified the identity of the general power of attorney.
Come to the impugn order.
My lord?
Impugn order. Comment substance.
Impugn order, under annexed 2.
By the way, you tell me one thing.
Ma'am.
In a 482 petition, you want a quashing of the entire proceeding against you. Can the court decide the 482 petition on the basis of pleading in a criminal case?
So my prayer is not for quashing the entire prayer, because I am working since.
What do you want then?
My lord, only for interim protection, because I am in the verge of the retirement and promotion.
Interim protection of what?
That is discharge petition step maguchum, because that has been rejected, ignoring all the valid points. They have rejected.
How do I know that these are valid points?
So, my lord,
that is, you say that is valid point, but these are pleadings.
So, my lord,
your petition.
My lord,
where is the charge sheet? Where is the FIR?
May I place my lord?
There is nothing.
No, my lord, without application, mind with the preponderance of thought, ignoring all.
If I'll pass some order now, that will also be a non-application of mind, because I have no exposure to FIR, no exposure to charge sheet. On the basis of your application pleadings, I have to decide. Is it possible?
Not possible, my lord, but some points have been raised in my petition that should be taken into consideration.
He is disputing that points. Then what will I do?
Only one point to be adjudicated. Because what is my role in the
adjudicated on the basis of what?
Man, there is
in a criminal case, how a court will adjudicate?
My lord, absolutely, there is no involvement of the petitioner in
right,
this
sir.
Case.
I am not saying that. You are right.
And my lord, due to pendency of this proceeding since 2002, now I have deprived it to get promotion to the rank of IFS below. This is problem, Milo. 2002 proceeding. And I am in the
there in the coordinate bench, I have given a judgment. You will get.
No, that
get the
relates to service matter.
You will get benefit now.
But for sake of argument, just I draw to your lordship's attention. This is my anxiety, Milo. Actually, petitioner was working under the administrative control of the concerned DOPO. DOPO is empowered to do all these things. While DOPO instructed by issuing a specific letter, Mr. SCO, please you issue TT permit. Accordingly, I have done my duty. And at that time, field
come to the impugn order.
May I place one thing, my lord? The impugn order was passed in 16/5/2022. And in the meantime, she has challenged that impugn order in 2023. By this time, charge has been framed and prosecution witness is going on.
Then, at this stage, how can I interfere? I will expedite your trial.
No, my lord, just
I'll expedite the trial, that's all.
No,
that's the best relief you can get at this.
No, my lord, just kindly lordship glance for a moment. This is an authenticated document because he is one of the PW4 categorically stated DOPO issued TT permit. So if DOPO issued TT permit, what is my role in this?
There is nothing on record. You have filed 2 documents. One is your discharge application, second is the impugn order. And you want me in the 482 petition, I should decide the entire, I scuttle the trial and everything and discharge you. Is it possible?
May I pray one thing?
2-page petition you file and you want that you should be discharged. Only two page petition.
No, my lord, taking some points, they should consider, let it be remitted, my lord, back. This is my
No.
limited prayer, my lord.
Once charge has been framed, evidence is going on. How, where is the question of remitting?
Charge, so many witnesses are there, just one witness examined, my lord, one witness.
Whatever, then I will have to pass that order of charge, again relegate it. No question of.
Or your lordship let the matter be target may be given, my lord. Because I mean
How many witnesses? You have not filed the charge sheet also. This is very unfair on the part of your office. At least you should file the charge sheet. FIR, nothing is there, and you want quashing on the basis of whatever pleading you are saying. Every accused will say that I am innocent. Now, on that basis, I will have to declare that accused is innocent.
Limited.
I have to see in a criminal case. I have to see the FIR.
Yes, your lordship.
Charge sheet. Nothing is filed.
As per documents available on record, I have filed, my lord. I appreciate your lordship's point, but this is the situation, my lord. Unless and until involvement of the issue, one person he faced.
How do I know involvement? What is the charge sheet? How do I know? How have you been implicated in the charge sheet?
My humble prayer, my lord, let it be remitted back for
No
consideration.
No.
On my points, my lord, under Annex 1.
We will not do that.
Because he has ignored all these valid points.
It's not valid points. Because these are pleadings. You substantiate those points on the basis of the documents.
Target may be fixed.
No document, nothing. You have said something that has to be accepted.
Target fixed karandu kete din bhitar close kariye.
I don't have that instruction because.
Ketra witness asante?
The witness 10 jana asante.
Ketra examine helani?
Jane 2 jana ହେଇଛନ୍ତି ଆହୁରି
ଜଣେ ନା 2 ଜଣ ସେଟା ବି ଜାଣିବ.
PW4 document ମୋ ପାଖରେ.
You come tomorrow.
2 ଜଣ
You come tomorrow with full instruction. I'll do it.
No, as per instruction, I have obtained 2 witnesses they have examined. Defense witness closed. Prosecution 2 jana asante. IO is also absent.
Where is the question of defense witness at this stage?
So as per I obtained instruction, my lord.
Are?
Defense
आपण prosecution evidence है नहीं आपण defense evidence पढ़ेले
ना से कौन मझेरी थरे जितर अटेंड करथले तापरे nobody is cooperating in this case at Jaipur court. That is problem.
Nobody is cooperating means accused person.
No, accused is presenting in all days, but prosecution side IO is even he is not presenting, he is filing time petition every day.
So means proceeding.
So let it be targeted.
May I suggest one thing, man? Your lordship may target it to conclude the trial within 6 months. If not, it will be concluded. Then
shall I record your statement?
that I
See, neither you know how many witnesses are there, nor he knows. He says the defense evidence.
Nah, he said
and you are making a concession.
No,
6
no,
months.
no.
Then again, after 6 months, there will be an application.
Prosecution witness. To my knowledge,
see, we can't pass some irresponsible order without
let it
knowing
come
anything.
Let it come tomorrow so that
it's very unfortunate that none of you know thing. And
this will come for the first time.
Tomorrow,
and he has not given the charge sheet.
You come tomorrow with the instruction. You come with
Mama.
Let him come with instruction. Tomorrow.
Melo.
The day after tomorrow. Day after tomorrow. You come seek instruction. How many witnesses are there? How many witnesses have already been examined?
Status of the
And
case.
what is the practical reasonable time we can give? Not that for the sake of giving time, you shouldn't give the time. Again, your application will come for extension. What is the use of it? Burdening the courts unnecessary.
Much obliged.
Item 7. And henceforth, whenever you are filing some petition under 482, at least FIR charge sheet, at least that should be there. Otherwise, how will you assess? This is very difficult.
So this is the lawyers who belongs to that area. That is the problem.
I know you have a handicap, but still you have to insist them. FIR to FIR the file kariyo.
Only came with some limited document. So that is the
that's the problem. Anyway.
Much obliged.
Yes. Nobody is there.
Nobody there.
February. End February.
Item 9.
May I please, here, 1cc case was filed. Your Lordship, time on 11.
What do you want here?
Yes, well, I am coming. I'll just close it.
11.
1cc case was filed. Offense under 294, 323, 324, 379, 447, 77.
The entire allegation is that the complainant has paid 95 lakhs in cash to me. I'm a developer. Developer has developed the area. 40% was given to the landlord, handed over. And now this FIR has been done. But there is a development in this case, I should tell you. But I have moved the bail application and the bail application which was rejected, allowing me to surrender. I know the limited scope of 482, I cannot seek a bail before your lordship. But I was given a notice by the police to appear, not a 41. I had appeared. Investigation was done. And in the investigation, when a question was raised that where 95 lakhs, how cash could be given? Because your lordship knows 95 lakhs cannot be given. They could not, the complainant could not satisfy. And there is a proceeding in the case diary. I only bring your lordship a call for the case diary if your lordship is convinced from the case diary that yes, the police have found this. I think it's a case for where a character has to be. Your lordship can invoke for it.
This is for quashing.
This is for question. Because now this is the development.
Are you interested to give to the land?
But he has already taken 40% of the land.
Land means
40% should not be taken. And the construction of the other portion is going on.
what was the promise? Land constructed.
Constructed 40%. I'm ready, madam. That is the investigation police has found out.
You are for informant.
Police has found. Your lordship, I only request.
See, I'll tell you, for these builders, threat to go to jail is the only thing. Once they will go to jail, you will not get anything.
And
So practically, threat should be there. Once they will go to jail, they'll say that I will not pay. You forget about anything. Whatever he has paid to his satisfaction, will you give so that I'll quash it? No. Cash you have given. That's what What is your case?
My case is I have the land. I have given him to. He has given 95 lakhs to construct the building. He has given that check to me. I have not paid that cash to him. He has paid 95 lakhs to me.
That he has paid you.
He has taken my land to construct a flat there.
Collaboration agreement.
Yes. He had to pay.
Construction has not taken place.
No. He
So
has.
what is your grievance? Construction is going on.
He
completed.
has given.
How many flats you are supposed to get?
40% built up area. 40% he will stake his name. But first he will get 95 lakhs to the land land money for taking that land. He has given that chance and tell that I will obtain the permission from the RERA and construct, and you deposit after month of February. And when I
deposited, got dishonored.
I got dishonored.
And
Then he
130
threatened me. Then he threatened me. You should do that third affair was.
Is there any chance of settlement?
Yes. If your lordship is convinced on the argument that yes, whatever I have stated is correct, your lordship will interfere or else your lordship will dismiss that.
No, obviously I'll dismiss. That's not the issue. I am finding out some way out if it is settled.
Yes,
At least that 130 it will go and this will also.
Fair one.
Yes,
You are not right.
we're fine.
That might be time barred. So therefore, arm twisting. You
No,
filed it.
already filed. That was already filed.
Then what happened?
138 in time filed.
What happened to that?
And no, exact date I will already
Yes,
130.
he filed.
Notice. Must be time, but that's why cognizance could not have been taken.
Address is different.
Your client is also not fair. His client is also not fair. Everybody.
No. Your lordship knows always there is a.
Well, produce case diary. Meanwhile, you explore the possibility. Shall I send you people to mediation?
In fact, police had
Yes.
mediated. Police on the instructs on.
Police mediation.
This was the finding out that not no money, the entire case is false. That's why I'm insisting that your lordship may call for the city. Police will give that report. I'm sure police will give that.
But why don't you go to mediation cell here and finish it up?
Yes.
Well, let the city come if your lordship feels that it's the person.
But keep it open, go to mediation cell. It is money and
Yes.
you can do that. No problem.
Well, first your lordship.
Call CD call for.
No, no.
Kati dini?
Next year.
19.
Chandrasekhar Pakra.
19. CD 19. Meanwhile, you try. Let's
Yes,
see.
yes. Oh, we are always
Okay,
ready.
70. No problem. 70.
Friday is always your lordship knows the half mood starts.
after half, you don't work. Anyway, 17. There is a reference also. Friday. Friday reference is also there. You may not get. Okay. 17. No problem.
And Friday is always post lunch is always difficult.
On 18.
That weekend holidays mood starts.
Mood starts. You are right. And in that mood only you can settle.
I think with my lord's intervention it can.
But the ideal thing is to settle.
Yes, yes. Well, we are ready.
Of course, not on the record. In spite of this FIR and 1cc case, but my client is proceeding with the construction and she has allowed construction.
So therefore there is a scope of settlement.
Yes, there is a scope.
Let us see the DD if anything can happen.
Item 18.
February end.
Item 23.
They are not interested. Why should you? February end, na? 23.
23.
Yes. February.
28.
See.
Note down. I may please your lordship. I may note down.
Wherever I'm adjourning for February, if they give memo, don't edit it. Because tomorrow they'll come again, mention nothing to do. Note down all the. Nobody is appearing and no question of. Yes. Yes, Mr.
Yes, Mr. Mishra.
Which item?
Which item?
28.
28.
But here is the case that petitioner is working as the. Lord, he's facing the.
Let him speak first. Yes, Mr. Mishra, can you hear me? Yes, tell me.
Lord, this is the case where Lord, the petitioner has filed this application for quashing of the proceeding, where the Lord petitioner is admitted like government servant, Lord working as executive engineer, Lord the power sector. Without sanction, the proceeding has been drawn up. So, my lord, in view of the Honorable Supreme Court judgment and the Lordship's judgment, it is barred by under Section 197 CRPC. This is the crux of the issue. Before that, I will come to your Lordship. FIR was lodged under Annexure, my lord, 1. Sorry, Annexure 2.
Yes.
Page 33, my lord. Of the brief, my lord. Where it is the opposite party number 2, the informant alleged that some important his signature was tampered, his copied by the office of the executive engineer, where the petitioner is the executive engineer. A letter was dispatched, so actually he lost the FIR. That the petitioner has filed certain false information before the Honorable High Court, this Honorable Court. Actually, given the Soro police registered the FIR, investigation was started. Well, surprisingly, without the sanction, the proceeding is undertaken. So, my humble prayer, once this action is 1971 is obtained, then the prosecution, otherwise the trial will be initiated. As your Lordship dealt with so many cases. Also, recent case is Universal versus State of Blood, represented by Inspector Police 2020-23. Also, some case law of this Honorable Court.
What you want to say is the sanction under 197 is a prerequisite for prosecution. It has not been obtained, so therefore quash it. That's what you want to say.
Instruction they may come up with. So
that's the point you have.
Only one point.
Yes.
I am not.
Whether sanction is required or not required, that will be considered by the learned court, where the proceeding is continuing. And this entire fact and circumstances is not during the course of discharging the public duty. So obviously sanction is not required.
It doesn't come under the color of duty.
Color of, so your lordship may kindly turn to page 47.
What is the allegation, by the way?
Well, here the charge sheet has been filed under section 420, 467, 468, 471. One document has been forged, but the signature of the complainant has been forged, and that has been sent to handwriting expert.
What document? Which document you are talking?
One, it has been entered details is not there, but I am reading some portion of the charge sheet 47.
Whether
page
that
47.
That document was to be used in official purpose, or what is that document?
Not that official purpose. That is a selling of property or something else. Well, I am reading. Your lordship may kindly see. I am reading.
Which page?
Page 47.
Okay.
47. Your lordship got it.
Yes, yes.
My lord. The his signature is forged, which has been produced before the Honorable High Court.
Don't read continuity. You read continuity. To this effect, the complainant, 47 second line. To
Seventh
this
line.
effect,
Yes, yes. To this effect, the complainant went to the Honorable High Court and filed WPC number so and so against a Electorac Soro. The Honorable High Court passed order to settle up the dispute regarding payment within a period of 3 months. According to the NESCO, authority intimated to the complainant registered post to appear before the executive engineer Electrical Soro for finalization of the matter, but the complainant remained silent, for which the NESCO authority dropped for his non-appearance regarding settlement as per the direction of the Honorable High Court, and also served the copy of the notice regarding dropping of settlement to him after obtaining his signature in the SR. On the other hand, the complainant further alleged that his signature is forged, which has been produced before the Honorable High Court, Odisha Cuttack. In this connection, Soro PS case note 268 of dated 28/2020 under section 420 IPC has been registered. My lordship got this point, and which under investigation. Steps were taken for the seizure of the original signature of Chandrakant Sabat, but it is found not available, for which the Xerox copies of question of the disputed document has been seized from the office of Electrical NESCO Soro. Thereafter, this specimen signature of the complainant Chandrakant Sabat suspects Bhupendra Nath Swai, Malayaranjan Swai, Narendra Prasad Swai have been taken in presence of executive magistrate cum Tahsildar Soro. Bhupendra Nath is the petitioner. Side by side, the admitted handwriting of the complainant and other suspects have been seized, and to unearth the truth about signature of the Chandrakant Sabat, the question and disputed signature along with the specimen signature, admitted handwriting signature have been dispatched to the handwriting superintendent of police CIDCB handwriting bureau Rasulgod Bhubaneswar for experts opinion by the SDPO Sadar Baleswar letter number so and so. Obtain the expert opinion from government examiner of question documents CIDCB HWB Rasulgod Bhubaneswar, in which he has opined that the person who wrote the red enclosed standard signature, which I have stands and marked as D1 to D39, did not write the dispute signature, whose photocopy has been stamped.
You come to page 46.
Yes.
During the investigation.
Yes.
First, on 20th August 2020.
28th August.
Soro case, so was
yes, 28th August 2020.
Chandrakant Sabat, so town, regarding submission of false document that is signature of the report of High Court of Orissa. I open show
Purported forced signature.
Yes,
is
Mishra. See, these are the allegation in the FIR apparently doesn't come under the color of duty. So therefore, no sanction is required under 197.
Yes. To the Millard FIR.
Some documents were forged, used in judicial proceeding, and on the basis of which the FIR is lost.
Yes.
The petitioner was working as a
And is it coming under your official duty? to forge a document and use in judicial proceeding.
That is the crux of this, because whether I have been I forged or someone forged.
That
Because
is a matter of trial.
that is a matter of
That is a matter of trial.
At that point of view, you humbly submit that when the petitioner was working as the executive engineer and in his office, the complainant, Lord informant, filed a representation. Honorable Court directed to dispose of the representation. Lord, I disposed of the representation, then it was directed to communicate the said outcome of the representation to the Lord opposite party complainant. What happens, Lord? The DACA register, diary register, there is a signature was there as if the complainant received the order of the present petitioner. That is the issue, Lord. It is the whole process of the executive engineer while exercising his duty as per the direction of the Honorable Court. But what the complainant did, complainant ko lage mo daskat ke jali kariki receive DACA khataru itaku
court re produce korche. Offense is committed in the court by producing that false document, and that has to be tested in the trial.
So, Milord,
Where is the question of 197?
197, Milord. Had it been, Milord, the case, if your Lordship go to the root of the issue, this is to tell the transaction is done at the executive engineer office at Soro and the petitioner of the executive engineer. Even if, Milord, the offense, whatever, Milord, that section 197. Yes, my friend is saying that if it is not fall under the ambit of the
How do you presume they can now produce also 197 sanction? You made them wiser by filing this petition. They'll do it now and produce it in the court.
Had it I commit crime in outside of I have taken bribe or something, but it is the allegation that my office has issued such order and a purported signature are reflected in the diary as if the complainant received the document, which is not actually he received. So this is the allegation. So my Lord, 197 is wholly applicable where as if the sanction is necessary. So my humble submission, let the case diary be produced, the entire record, whether the signature was there, whether the court petitioner has tampered or not.
That has been mentioned here. That has been mentioned in the charge sheet. Entire things have been mentioned.
See, my prima facie view is sanction may not be required in this case because the act complained of is not coming under the color of duty.
Kindly see page 35. What is the FIR? Kindly see.
So if you want a finding on that, then a vital defense of yours is closed.
Bow down your Lordship's view.
Are you going to bargain that risk by insisting this petition?
One aspect, Lord, 35, page 35, can you see the FIR? Your Lordship will see the FIR. Feel the official duty is there. Page 35, Lord, I may permit to place.
30?
35.
35.
This is the FIR with the basis of Lord the prosecution. To the IIC Soro Police Station, Soro. Your Lordship got the page, my Lord.
35, huh?
35.
You're talking about 35?
Yes, my Lord, 35.
Okay, I got it.
The subject, Abhijog Jahaki, Soro Electrical Division NESCO, Executive Engineer.
Bhupendranath Sahu.
Milord, audible, Milord? Am I audible? Milord, am I audible?
No, your voice is breaking somehow.
Sorry, Milord.
I'm putting it day after tomorrow. You come.
I'm in Delhi, so Milord, it will be Monday.
There is a problem.
Yes, Milord. Just
day after tomorrow.
Yes, Milord.
Day after tomorrow.
Yes.
Grateful, Milord.
Voice asuni clarity.
What a problem.
It's a problem from that side.
Yes, that side. Mobile ta rakhichen to mobile.
Okay, day after tomorrow.
Grateful.
Hey, keborate petition ta?
Decision ta again 2023 re ache again. Mo case ta squarely cover karuchi. That is why I am humbly that a petition is executive engineer. But jodi sanction ta heigala, then there is nothing.
Sanction kahi nahi unati apana.
Sanction record. That's what law. Court is there.
Why are leaving a gap? Take sanction and place it. Generally that happens.
EFO came after
When
5
these
years.
kind of petitions are filed, sanction is obtained and placed. Defective sanction हो जहाँ भी हो कर दो. Day after tomorrow.
Day after tomorrow.
Lord, your lordship may call for the case diary so that your lordship may
No, you satisfy. According to me, it is not coming under the.
satisfy with the citation judgments and the fact of the case.
Day after tomorrow करियो बेसी जो.
Monday क्या कर दूँ? Monday, Millard.
Monday.
Monday.
Okay, Monday. Monday, okay.
Monday.
Monday.
पक्का भेज लिया ना